Hello, good morning, and welcome to NewsFile. This is your most authoritative news analysis platform. And here on NewsFile, as you know, we put Ghana first. This morning, the Supreme Court has unanimously voted for a new voters register without use of your current voter's ID as source document. The court has also literally outlawed any further suits against the Electoral Commission's pursuit to have a new voters register. We examine the implications, if any, in the landmark decision to give room for a new voters register. 41 MPs have lost their bid to return to Parliament on the ticket of the New Patriotic Party. We examine the implications of that, particularly for the future of the NPP in Ghana's Parliament. We have questions, including whether this exercise, called primaries in the NPP, was an auction sale. Why was the prohibitions and the measures to help Ghanaians against catching COVID-19 so blatantly ignored and violated during the primaries? Is that a sign and a warning going into another mass exercise as the registration and the elections to come? Nigerians are not happy about Ghana at all. In fact, their representatives have very harsh words for Ghana. They are asking for retaliatory measures, as some buildings within their embassy here in Ghana were pulled down. They blame the government for it. We will deal with all of these vexed matters right here on NewsFile. Don't go anywhere.
A rally or what have you of the NPP, and look at this: no social distancing, no face masks. All these things is going to increase the rise of the COVID, and it will multiply. And in the next 2 weeks, we may probably have another 5,000 rise up. Now we are around 13,000, 14,000. In 2 weeks from this situation, it's going to increase by 5,000 more. And unfortunately, when they come to church, then they will say that it is the church that has produced this. And they have stayed there for more than 2-3 hours. And yet they said for church, we must only meet for 1 hour. And some churches, when they met during the lockdown, they have been jailed. And yet these people are doing what they don't need to do. It is like 4 legs bad, 2 legs good. If the law is the law, everybody must obey the law. And I want you to understand, whether you see me by video or by any media, don't follow the politicians. They are not thinking about your well-being. I'm saying politicians, whether NDC politicians or MPP politicians or WXYZ politicians, they don't care about you. They care about their election. And whether you are alive or not, whether 1 million people die, they don't care. So don't follow them. Don't follow them. Wife your children, because nobody will take care of them for you. May God give us wisdom. May God guide.
And that was my take from Bishop Samuel Mensah. My only wish and hope is that the men of God will be as bold and as blunt rather than how we have seen some of them conduct themselves. They would actually be the voice of God and represent the people truly. Please wear your face mask. Obey all the protocols. They are for your own good. And you are listening to people complain about wearing the face mask, and they are complaining, are we supposed to wear it when we are in our cars? Well, even those who are not supposed to be in cars, those who are not in cars, are not wearing them. Driving on the street, I see many people, they are not wearing it. So let's stop complaining about wearing it in cars or not. Just wear the face mask because it could protect you. And police are not doing anything wrong when they say that the law requires you to wear it even in your car. They have not interpreted the law. They simply read out the law to you. Paragraph 1 of the EI says that lazily drafted EI, because there ought to be an EI that is properly nuanced, comprehensive enough, that takes care of situations where people may not be able to wear it. People who may be asthmatic for certain reasons may not be able to wear it at certain quarters. You don't draft a generally lazy EI and then come to say police is seeking to enforce it by a literal approach, and that you are talking to them to approach it with a purposive interpretation. Police don't interpret the law on the street. The interpretation of the law is for the judges to do in the courtroom. And the EI says, wear the face mask, wear a face shield, or wear a face covering when you are in a public place. A public place includes the road that you drive on. Then it goes on to say, wear it when you are leaving your home or when you are returning to your home. If you are leaving your home, walking or driving, you are leaving your home. The law says wear it. If you want the police to approach the law in a different way, please go and amend it. And this is only a president-only made law. It takes 1 minute for the president to use his pen to change the manner it ought to be. The police, as I have been reading the police diary, focus on Accra region, are so ready, they are not going to take any excuse. Because guess what? I'm reading this and I'm realizing police are dying because of COVID-19. So they will implement it to the letter. Just wear your face mask or your face shield or your face covering. That's my take. Thank you very much. Now, we will begin the show. I'm going to introduce my guests to you. You already know them, and many of you are excited to have your finest street pocket lawyer who is on a victory parade. It's on a victory parade in the studio because he has won a very sweet victory in the court yesterday. But listen to President John Dramani Mahama. We'll come back, I'll introduce them, and then we'll have a discussion.
Despite the well-reasoned reliefs we sought, the apex court of our land has given a leeway for the Electoral Commission to go ahead with the exclusion of the existing voter identification card from the list of identification requirements for the registration for the register. My brothers and sisters, we're deeply disappointed, and we strongly disagree with the court over this outcome, which has confounded many legal experts and indeed has thrown the whole country into a state of confusion. Our legal team is examining this decision even as we await the full reasons for this judgment. It is also worrying that the court deferred the reasons for its decision to the 15th of July. a date by which time the EC would have been 2 weeks into the said registration exercise. We must always be willing to hold leaders accountable for bad decisions that impose difficulties on our citizens. And this is one such clear opportunity to do so. Do not let the several hours you may spend at the registration center get you to surrender your right to vote. If you do so, that will only embolden those who seek to disenfranchise you. To the few who have passports and Ghana cards, please make use of them and register. And to those who get the opportunity to register, I implore you to assist your brothers, your sisters, and compatriots by guaranteeing for them, even if it takes a bit more of your time. Please see this as a civic duty and your contribution to the efforts to preserve the right to vote. This way, we will undo the grand conspiracy to deprive us of the inalienable right to vote, and we will, in the process, send a clear signal that it is only we, the people, who will decide who gets the opportunity to lead this country, and not governments we elect or state agencies who make themselves pliant accomplices in their attempt to disenfranchise us. We have been very clear in our minds that the decision to compile a new voters register was in pursuit of this long-held agenda. Hence our efforts to stop the wholesale attempt to exclude vast sections of our population from the process to determine who leads them. This represents the handiwork of a desperate incumbent that, on account of its very poor performance in government, sees its very political survival only through the prism of manipulation of the electoral process to exclude a section of Ghanaians who they suspect may not renew their mandate at the polls. A caring, compassionate, and responsible government would not push us to the brink at a time of a major pandemic such as COVID-19 that is causing so much anguish amongst our citizens. It is deeply regrettable that the Electoral Commission, which should be independent and has carved a niche for itself as a well-respected commission in the whole of Africa, has today made itself a willing tool in the execution of this most diabolic agenda. The exclusion of the old voters' ID card, which has been used to conduct several elections under the current leadership of the Electoral Commission, and from which the current president derives his mandate, is aimed at deliberately disenfranchising some Ghanaians who have falsely been branded foreigners without any basis. The restriction of primary identification to passports, Ghana cards, and the resort to guaranteeing for others is a ruse to create frustration in the hope that it will discourage millions from registering, and in the process, it will give advantage ab initio to a bungling and inefficient incumbent. This is not just an NDC fight. It is a fight to rescue the very soul of our beloved nation from the hands of those who seek to impose their will unjustly on our people. Our forefathers founded this nation with the motto, freedom and justice. It is clear today that never in the history of our Fourth Republic have these two lofty ideals been in such short supply. I salute all the diverse organizations, civil society organizations, prominent chiefs, organized labor, religious leaders, professional groups, and all well-meaning Ghanaians who have rallied around this cause to demand that the right thing be done in the larger national interest. I call on all Ghanaians who yearn to see a change in the governance of this country to rise up and be counted, for where there's a will, there's a way. No politically engineered register can save this failed government. From the judgment of the people, from the inevitable defeat that awaits them in the next 165 days. With or without a new voters register, the NDC shall win the election by the grace of God.
You're welcome back to NewsFile. This is your most authoritative news analysis platform, and you just heard President John Dramani Mahama and his reaction being the party's, NDC party's official reaction to the ruling of the Supreme Court, or judgment of the Supreme Court in the matter regarding the voter registration exercise that is to start as a Tuesday. Well, so we will look at his statement briefly, and then we will zoom in directly into the decision of the Supreme Court itself and any implications, if there are. My guests, and like I said, many of you are very excited. Abdul Malik Kwekubako, editor-in-chief of the New Crusading Guide newspaper, who has since yesterday been celebrating a judgment of the court that puts some 130,000 Ghana cedis into his pocket just because somebody opened their mouth in a manner that they couldn't substantiate in the courtroom. So just be careful what you say. Kweku, welcome to NewsFile.
Thank you, my brother.
Great. But I'm checking once it hits the account. You know, I'm your friend. I was hoping, though, that the damages could have been a lot heavier, because I read the transcripts and I found that there was no defense whatsoever to those claims against yourself and your boy Anas, like they say.
No, whether he asked for punitive damages.
I did.
He did.
Oh, you did. Okay.
He did. Yeah. All right.
But you know, give a quick one. There.
Yeah.
That area, the quantum, all that, you are lawyers, I'm not. But I think that's within the discretion of the court or the presiding judge.
Yeah.
We asked for something. I'm not sure what you asked for is necessarily given to you relative to the monetary aspect, the damages. But what was more important was the other things we asked for. You know, the retraction and apology.
Yeah.
And the way, and 3 times on each of the platforms he did. That for me is very important.
Okay.
The perpetual injunction against repetition of those obvious untruths, or if you like, complete lies.
Right.
You know, so for me that's more valuable. Integrity can never be monetized.
That's right.
In any way.
Yeah.
So I'm happy with what has
The Bible
happened.
says a good name is better than riches.
Thank you.
It can never be repaid.
Yes.
Yeah.
And the 100,000, it's not coming to my
I thought
pocket.
it was 130.
It definitely is going to some charity.
Okay. He said 100,000. That tells you that, you know, he's decided that the 30 should go to council.
Okay.
So don't stress it.
Okay.
All right. Okay. Thank you very much. Now, so officially, and the courts have sanctioned, he's not in any way involved in anything even remotely close to Galamsey.
But you know, my nickname became Kweku Galamsey
Yeah.
on social media.
Yeah.
Yes. And also, there was no attempt to blackmail the president. There was no secret recording of the president's encounter with Anas.
All right.
And there was no evidence provided to show that people who are appointed ministers of state had to come to the coffee shop mafia for endorsement before the president did so.
Yeah, when you read the transcript, you get clearly that most of it was not even rumor, just somebody just talking. Right. And as you know, Anas too has one explosive that is coming up. So just watch out for it. My next guest here in the studio is Dr. Dominic Ayine. He is MP, Boga East, former Deputy Attorney General. Thank you very much for joining us, sir.
Thank you, Samson.
On Zoom is Kofi Abochi, Dean, UPSA Law School. Dean Abochi, thank you very much for making time. Right. And Joseph Dindiok Penka is the MP Timpani and Deputy Attorney General and Minister for Justice. Thank you for joining us, Penka.
My brother.
Great, great, great. Okay, so let's start on this note. What the President Mahama read clearly was carefully written. That's lethal. That's a statement that clearly seeks to decimate the judiciary, as in the Supreme Court, the NPP, and the Electoral Commission, as if they were involved in some criminal enterprise. This was clearly thought through and written and presented.
Well, I think, Samson, you are entitled to your view and your interpretation of the statement of His Excellency John Dramani Mahama. But put in its context, I don't think that the statement was aimed in any form, shape, or manner at decimating, in your own words, to quote you, the institutions you've mentioned. The basic point that he was making was that we accept the decision of the Supreme Court, but we are unhappy with it because of the dire consequences it has for the ability of the masses of our people to be able to, easily register and then exercise their right to vote. The reference to pliant, institutions, that are pliant in or complicit in a grand scheme that is aimed at suppressing the votes. Or
in fact, he says this represents the handiwork of a desperate incumbent.
Yes,
that on account of its very poor performance in government, sees its political survival only through the prism of manipulation of the electoral process to exclude a section of Ghanaians who they suspect may not renew their mandate at the polls. Yes. Manipulation.
Yeah, that is so. The
NPP is manipulating the court and manipulating the EC.
No. Please. I think when he talked about the manipulation, it was in relation to the organization of the registration exercise. It wasn't aimed at the court. I don't think that, His Excellency, with all of us, experienced lawyers, with him on that platform, were seeking to say that the NPP has manipulated the court. That is far from the truth. What he was trying to say is that if you have a state institution, such as the Electoral Commission, all right, that has over time shown that it is, everything it is doing now is in conformity with the demands of the ruling party.
And to use Mr. Mohammed's words,
yes,
this is a commission that has made itself a willing tool,
yes,
in the execution of a most diabolic agenda.
Yes, those are very strong words directed at the commission. The commission is independent under the Constitution. And something you and I know that when the commission, and I want to put this matter in context. The commission in Abu Ramadan versus Attorney General and the Electoral Commission staunchly defended its record of compilation of the voter register under CR 90, the Public Elections Registration of Voters regulations, CR 91. When it was asserted by the plaintiffs in that case that the register was not credible and should be declared unconstitutional, okay, the Electoral Commission then decided to defend the register, okay, and said that the register was credible. In fact, there was nothing wrong with the register, and therefore the Supreme Court should dismiss the claims of Abu Ramadan. The Supreme Court upheld some of the claims of Abu Ramadan, but ordered the commission to clean up the voters' register. They managed to delete 65,000 names from the register through a process that was supervised by the court itself. All right. So, 4 years down the line from that litigation, the court then turns around and is talking like the plaintiff in Abu Ramadan, basically saying that all along, all these years, from the time of the respected Afarijan, of course, Afarijan took over, I think, after Justice Ofori-Boateng handed over. But from 1992, Afarijan was part of the process of building that institution and building its reputation that the former president referred to. That from 1992 to the present, okay, everything that they have done by way of registration has been constitutionally flawed, to the extent that they asserted in paragraph 35 of their statement of case filed in answer to the second suit brought by, Techi Benson. Okay, they asserted in paragraph 35 something that 12.5 million, okay, of the 15 million names on the register were registered without verification. In other words, all this while, under CR 91, we have a voter population of 12.5 million that was unverified. Now, who was in charge of verification? The Electoral Commission. And remember that this is a state institution. It is a continuum. This is not a Jin Mensa.
It is important that it's a state institution, it's a continuum, but it's differently constituted.
No. It's not differently constituted.
It is.
Not differently. When you use constituted, all right, you are talking about the appointment of the commissioners. Okay, the institution itself was constituted upon the birth of the Fourth Republic under the 1992 Constitution.
You were Deputy Attorney General. You may have had a policy you were pursuing. If someone else has the opportunity to take over that office, they could pursue a different policy.
No,
that department is a continuum.
But let me draw a distinction here. You see, governmental policy, all right, of the kind that you are referring to. So, for instance, our policy on the criminal justice sector, would have been different from let's say the current managers of the Attorney General's Department can decide that they want to depart from that policy, all right? However, we are dealing here with an independent constitutional institution that has prepared a register, all right, which is the basis of our democratic, elections. And you are saying that because there is a change in management, that register can willy-nilly be thrown away, and the institution can actually engage in what I call, institutional self-deprecation by simply saying that, we have been doing things in, we have been violating the law all this while.
We'll deal with the germane, perhaps, need, as the Attorney General argued in the court and the Electoral Commission argued in the court, why there was the need for a fresh or clean start, looking at the statistics of our population and various, situations where there appear to be an obvious over-bloating of the register, which needs, re-engineering. But you say he didn't attack the court.
No,
listen to this part. He says, you went to the Supreme Court informed by the party's time-honored belief and commitment to an inclusive democracy as opposed to the MPP's inclusiveness. Listen to him. MPP's exclusiveness.
Yeah.
He says, however, it was obvious from the outset of this struggle that inclusive democracy was not going to have a hearing. Who is he talking about? The hearing was in the court.
Yes.
Inclusive democracy was not going to have a hearing, even against the resounding call by the National House of Chiefs, religious bodies, CSOs, and the various trade professions, among others.
No, but now that you have amplified the statement, that statement cannot be taken as just a reference to the court. To the court. All right. There are a number of state institutions involved in this exercise. The Electoral Commission is one. All right. And then the judiciary by way of the suit that we filed. So I think that this, a statement in context is a reference to the Electoral Commission not wanting to listen to all the pleas that, you know.
You want us to discuss this beyond the internal context of this particular statement?
Oh,
because you're bringing a context that doesn't appear to be right here in the statement.
No, I was part of that context, and that is why I'm explaining to you. All right, and as I said, okay, there was no way in hell that those of us who advised the president and those of us who were part of the process of crafting this statement would have meant that we wanted to attack the judiciary. Okay, what the president said was very clear. He accepts the decision of the court. In fact, he has no option, and we would have advised him that he cannot, come out to say we don't accept because we are all bound by the decision of the court. All right. So the reference to inclusive democracy not having a hearing from the onset is the posture of the Electoral Commission as far as these issues are concerned. It's got nothing to do with
he says,
the Supreme Court.
As he gets to end, it is clear today that never in the history of our Fourth Republic have these two lofty ideals been in such short supply.
Yes.
What is he talking about? The ideals of freedom and justice.
Yes.
Freedom and justice.
Yes.
He was commenting on the back of a judgment.
Yes.
And he says these ideals of freedom and justice are in short supply.
That is true.
That is the Supreme Court he's talking about.
Not exactly. All right. Our freedom is not trampled upon only by the Supreme Court. The decisions of the Supreme Court. All right. We have a situation where the freedom of the media. Okay, from the 2017, your own colleague had to be taken to South Africa. Manasseh Azora-Winnie had to be taken to South Africa because he said things that they displeased the ruling party and then and its foot soldiers. So when you make a statement in this context, it should not be, just interpreted to mean that that is a reference to the court. And in any case, okay, justice is not only a judicial concept. All right, justice, can be dispensed by administrative authorities. So if an administrative authority makes an unfair an unfair decision, either substantively or procedurally, you can criticize it as, something that is undermining justice.
Thank you. We wanted this to be brief, then we'll get into the judgment itself.
Right.
Although there are no reasons, people appear to speak as if the court has given reasons for its decision. Banka, what do you have to say about what John Mahama has been saying about the judgment, about you, the NPP, and about the Electoral Commission? There is a trinity of a travesty against the Ghanaian people, he suggests.
Well, Samson, I have listened carefully to what the former Deputy Attorney General and Minister for Justice, Honorable Dominic Aine, has said. And I can see clearly that my learned brother is struggling very hard to defend what the former president said. You see, put it in context. At the very onset, the former president said that they vehemently disagreed with the decision of the Supreme Court, even though they respected. That was how he started the whole of his speech.
Yeah, even though that is not strange language. When you are appealing against a decision of the court, you will use vehement and the rest of them. Yeah.
Absolutely. But you see, you realize that when you put the former Deputy Attorney General to strict proof of certain aspects of the speech, he was talking about Manasseh Azure-Awuni going to South Africa. That was complete deviation of the issue. It was a complete deviation because the former president was commenting on the Supreme Court decision that was taken earlier in the day. No dispute about that. That was what he was commenting on. And he spoke about the fact that the actions of the Electoral Commission and etc. is a dent on our democracy. Samson, he talked about trying to disenfranchise a number of Ghanaians and etc.
Not trying, deliberately.
Yeah, deliberately. But let me state this. Are these not the issues that were presented to the Supreme Court and they were dismissed? So if the Supreme Court dismissed it and you are talking about a grand conspiracy and etc., are you saying that the Supreme Court is party to that? Because, you see, the issues you raised against the Electoral Commission were not upheld. If the issues you raised against the Electoral Commission were upheld by the Supreme Court, then you could say that the Electoral Commission was acting deliberately to disenfranchise Ghanaians. But if the Supreme Court dismissed the relief that you sought, and yet you are coming out to say that it's a deliberate attempt by Electoral Commission to disenfranchise Ghanaians,
John Mahama, President John Mahama doesn't say the suit was dismissed. He says that they had well-reasoned reliefs, yet the apex court gave the leeway for the Electoral Commission to go ahead with the exclusion of the existing voter identification card. So it's not simply dismissed or refused. He says they gave them a leeway.
You know the point is, Samson, if you have read the summary of what they released as the decision, the dismissal of a number of the released sought, and then the specifics of talking to uphold some of them, and the way it was carved out. Clearly, I mean, that's why I even stated, I know you'll be going into the details of the matter,
right.
But very clearly, it is the decision was simple. The summary of it was that go and register in compliance with PI 126, period.
Okay.
So what it then means is that what you came to seek before the court was dismissed. That's the simplest explanation that one can give to the whole of this and then end this confusion that we have actually inflicted.
You are on the line. We'll be finding out the justified grounds for that. Yeah. But Kweku, what do you say to President John Mahama in reaction to what he had to say?
Well, you know, initially, I mean, before he spoke, there were some announcements and hints and things coming from within the NDC's own communication network to the effect that the former president was going to speak to the nation. Quite a nice headline. And then when I heard him speak, and I've read the speech here, I realized that it was the politician in him that was speaking, not the former president in him. And indeed, he was not addressing the nation. He was addressing party partisans. And the content analysis of his speech...
Does it not matter that what he says resonates with a section of the population?
Well, it might. Because there were other groups that believed in the NDC's cause. So I will concede to that effect. But I'm saying that when you do a content analysis of his speech, the address that was supposed to be to the nation was more directed at party partisans. Hence, some of the issues you've highlighted for my brother Dominic to deal with was a political speech. He invited us into the realm of interrogating conspiracy theories. He played on the keyboards of his party supporters, their emotions. He's entitled to do that. That's a politician. That's why I began by saying it was the politician in him that was speaking. Otherwise, look, a court had just delivered a verdict. Yes, I know they have top lawyers, very good and intelligent ones, including my brother sitting here. But I think that they didn't take their time even to check and review what exactly had been delivered. Otherwise, the General Secretary would not have done what he did, whilst surrounded by lawyers, some of whom had a role to play.
You talk about him claiming victory.
Exactly.
Okay.
And saying all sorts of things.
Specifically with respect to the inclusion of the voter.
Yeah, but that for them,
I'll come to that.
Yeah, we'll come to that. There was all
use those words that this is victory for you.
Yes. Don't forget, they had embarked on a trail of shifting cultivation from day one. Today this, today, tomorrow that. So now the idea was that, okay, once we got that particular relief when they thought they had,
we have
that
it.
You had it?
We have it.
It says they have it.
We have it.
We will interrogate it in that sense
I will need
of a legal analysis.
Yes.
I will need some
see whether
and I will explain
they have a point by claiming that they were giving the opportunity to have the existing voters' ID card used as an identification document.
Yes.
And that was relief what?
Yeah, we'll get to that.
Okay.
We'll get to that.
I will need, I'm prepared to learn from lawyers. I'm just at the street corner.
Right.
Mine is not law. Okay, but the point really is that, and there's no need to over-elaborate, the things he said, if you permit just 2 or 3.
The contradiction, though, is that he says they got it, yet they advise and may have worked on this statement, which says it has been excluded.
Thank you. Need I say more? Yes, that's what I mean. You see, the confusion, the conflicting signals, the inconsistency, the contradictions over a period. And I'd had cause actually to caution them that, look, they better focus. This is a political party in search, in pursuit of political power. Come elections, that is only about 6-7 months gone. Get your support base focused. But the signals are too conflicting, too contradictory, too inconsistent, and indeed internally incoherent. There are times I don't get the message. Now here we are being told by Dominic that they got it. Yes. And this means they're relief 4.
No, reliefs 2 and 3.
2 and 3. But subject to. I mean, you better than I am. I mean, this
like
is
I
subject
said,
to.
Let's not get there. Yeah, we'll deal with it.
Subject to. I don't see how you can read the first line in isolation from the second line. That would be amazing.
Okay.
I mean,
let's pick okay.
Wait, no, please, please.
Let's pick Dinabuchi's views on what the President Mahama had to say. What do you say?
Well, so good morning. First of all, I think that it's perfectly in everybody's right, or anybody's right, to make comments post-judgment. So the former president, as a citizen of Ghana, speaking in his capacity as a citizen of Ghana, he has the right to express his opinions as far as the judgment is concerned. I think the point has been made that the statements that were made by the former president obviously are unproven facts. These are opinions of the flag bearer of a leading political party in Ghana who is expressing his position on the judgment and reading meanings into them. I think it is instructive for us to know that he will not be the first, and probably not the last, maybe the first former president who has expressly made those statements on national television and radio platform. And that's where probably it may be a bit disturbing. It may be disturbing to the extent that when you speak in that capacity, because he is the only former president, I think context is important. Because he's the only former president who is contesting election. The other former presidents we've had been sitting presidents who contested election. He is the only former president who's contested election from an opposition camp. In that respect, the context may be instructive. And I think that is what partly explains why he is the only former president who may be casting aspersions at state institutions. And that is disturbing. The reason it's disturbing is because as a former president, he has been in the thick of affairs. He has been the vanguard and guardian of our constitution. He has been the leader of enforcing the laws of this country. And therefore, when he speaks from the perspective of someone who has been that close and, chiding or chastising institutions in creating the sense that these institutions may have been compromised by a sitting president or by a government, then invariably one gets worried. So I worry about the bastardization effects of the comment. I would have dismissed anybody who says these things. There's so many conspiracies in town. Conspiracies invariably may end up being true or being false or being partly true or partly false. People will listen to them and just move on. But when you have a former president making these comments, and from the position of being a former president and leading a major political party into an election, making these comments, then it's sobering, and it sort of creates a sense of worry. Look, we have to be realistic about these things. These conspiracies and these conspiracy theories and these suspicions of remote controls of our state institutions. They are nothing new. And the generality of Ghanaians, I think, by and large, have some suspicion surrounding these. But once they remain in the realm of suspicion, they remain where they are. But when you have, again, somebody like the former president in his capacity as a former president and going into a new election, making these statements, then it moves from the realm of suspicions and general, if you like, bystander allegations to one being made by someone of a high level of responsibility who is not only going into an election, but who has actually been the head of state of this country before. And so I will, my only counsel is that I would counsel that we probably tone down a bit on that. Okay. Because our institutions, I think, have come a long way. They are certainly not perfect. Yeah. But there's always a danger of bastardizing them.
Right. What advice as a lawyer and law teacher and dean of a law school, what advice do you have to members of the public who make permutations looking at judges and who appointed them when they sit on a matter like this? Because for most of the people who belong to the NDC, that is the prism in which they make some of the claims and find grounds for its acceptability. That you have a matter brought by the NDC and a Chief Justice just appointed by the current president, and a panel of 6, he included, making 7, and the total number 4 are people that he has just brought into the Supreme Court. What do you say about some of these things? Because it keeps recurring and people point to, but who brought this man? Who brought that man? What do you say to that kind of analysis?
Those analyses are strong and they are worrying. I have to say this. For so many years, I've always tested my students. I haven't done recently, but I used to test my students whenever there's a major decision coming up, for them to vote in anticipation of the decision and for us to test the extent to which the decision will coincide with their suspicion, so to speak. Interesting. A lot of these students tended to get their votes incorrectly. And when you ask them why they voted a particular way, their simple response is because this judge or this justice was appointed by government X or party X. That is troubling. I have had the opportunity of interacting, and I'm very honored to say this, I've had the opportunity of interacting with some of the justices in different fora, and I've mentioned that I think the justices have to strive to become identified with a certain, not only ideology, but a certain principled level of decision-making, as opposed to how they are appointed. Now, I'm not saying that they make decisions on the basis of how they are appointed, but I'm just saying that I think the justices have to strive to become identified with certain principled level of decision-making. That identity will shake off the party identity. Now, I need to also say this, that it is instructive that when the Nana Akufo-Addo versus Mahama decision was rendered, the election petition decision was rendered, a lot of Ghanaians were particularly surprised, or at least a lot of Ghanaians that I interacted with were particularly surprised at the fact that a particular justice, so I don't have to mention the name, but a particular justice voted against the petition. And the expectation, or the reason we're surprised, was because that particular justice, in their opinion, was appointed by a certain political party. The problem always comes when people associate justices with political parties, because you tend to insulate them, or you tend to take away their judicial cloak, and then you put on them the impression of political parties. Perceptions are strong and they need to be dealt with. Now, the way to deal with perceptions is for the justices to assert a certain level of, I would not use the word autonomy because they're supposed to be judicially autonomous, but a certain level of identity, which is different from what people normally associate them with. And I can say, or I must say that they may not necessarily go out of their way to give decisions that associate decisions that are in support of parties that appointed them. But if judgments are consistently seen in a certain prism, and the court itself doesn't appear to be interested in dealing with that perception, brushes it aside, but basically just goes ahead to give decisions on the basis of what they consider judicially right, these perceptions may continue to rage. in American jurisprudence, there has been the question as to whether justices should be concerned about public perception or public outrage in terms of their decisions. After all, judgments are supposed to be in accordance with justice, with law, not in accordance with what people think. It is not a majoritarian decision-making process. So courts do not really care whether the outside world thinks of them in one way or the other. What they are more interested in, whether they have done justice according to law.
Okay.
But for constitutional decision-making, because constitutional decision-making has a high level of political party impressions, because invariably the stakeholders and the beneficiaries tend to be the political actors of the governance system, justices and judges cannot remain, as it were, unaware or remain in a bubble and, as it were, pretend that the outside world doesn't have an influence. So I do think that these perceptions are there, they are strong, and they undermine the perception of justice. And that is why, moving forward, it's imperative that at least some attention is paid in terms of the perception of the public vis-a-vis their appointments.
Right. We take a break here and return to look at the judgment in perspective. But I needed to make a statement that even like Abuchi himself, who taught me this American jurisprudence in constitutional law, whilst even in the American jurisprudence, you can predict what the court will do because of the idiosyncrasies of the judges involved in a particular case. If a judge has had the daughter raped or something, you could tell their disposition if they are dealing with a rape matter and so on, because they are humans. They are not angels. But we know that once a judge is appointed, many judges have disappointed those who appointed them. Yeah. And we have a lot of that in this country. Exactly. Once you appoint them, you have no idea what they can do because you can't remove them. Yeah. We'll be right back. You're welcome back. This is NewsFile. It's your most authoritative news analysis platform. And here on NewsFile, we put Ghana first. So we just finished with a first segment where we sought to examine and critique the former president's reaction to the judgment of the Supreme Court. Of course, you may have heard others who would like to put what the former president said what candidate Akufo-Addo had to say when he lost the election petition. And they want to weigh the two to see who will gain a lot of international attention and sympathy for how they react to these situations. You know, Akufo-Addo shot to international fame, so to speak, by his statement when the Supreme Court gave its judgment. Now, let's get to the decision that the court gave. So, start with Pamka. Hello, Kwanka.
Yes, I'm on the line.
Great. So we start with you. For you, you went to court to defend the case, and you did it successfully. You won. This is victory. But the decision of the court, you don't find anything, for example, that gave rise, even if small, to the confusion that ensued from the beginning by the grant of Reliefs 2 and Reliefs 3 that the NDC sought?
Thank you very much, Samson, and thanks to your many viewers and listeners. First, let me say that when you read a judgment or when a court renders a judgment, for you to understand it, you have to construe it as a whole. You lend yourself to total confusion if you pick and choose phrases, clauses, and sentences and paragraphs and read them in a manner as to suit your interest. That is where you run into difficulties. Sometimes you run into very embarrassing situations, irredeemable of your image, and etc. So the most important thing is to construe the judgment as a whole. Now, the reliefs, as were sought by the plaintiffs, the judges, learned justices took their time and looked at each one of them and then either dismissed it or granted it with caveats or conditions. Now, if you look at the various reliefs, the majority of them were dismissed. The two that were granted subject to CI 126. So if the commentators lawyers and etc. had taken time to read the reliefs as they were actually granted by the court or rejected by the court, we would not have come to the conclusion we did. But there was a hurry to respond to or comment on the issues without due consideration or careful thought over the issues that were actually brought out by the court. Now, clearly, if you look at the issues, those that were dismissed, we don't need to even debate that because they were simplicity dismissed. Now, if you look at those that were granted, and they were granted, as I said, with a caveat. And what was the caveat? Subject yourself to CI 126. Now, whatever is granted, if they say subject yourself to CI 126, what is a CI 126 is very simple. That you go use a passport or a Ghana card or get two people to guarantee for you to register. That's what is there. So whatever you took to court, if they tell you to subject yourself to CI 126, and what you took to court is not in compliance with CI 126, it means that simplicity is dismissed. So the confusion that followed the judgment, for me, was the rush with which people wanted to comment, when in fact they did not take a careful look and view at the decision of the court. As you have rightly pointed out, they have not given the detailed reasoning, and they've deferred that to a later date, which is not strange anyway. But the most important thing now that we should be doing in commenting on this is to limit ourselves to what is before us now. And what is before us now, simplicity is what I have just adumbrated.
Yes,
So
but let's look at it this way. Relief 2 that was granted, clearly understood. They asked the court for a declaration that upon a true and proper interpretation of provisions of the Constitution, specifically Article 51, read conjointly with Article 42 of the Constitution, the power of the Electoral Commission to compile and review the voters' register must be exercised subject to respect and protection of the right to vote. And the court agreed with them.
But something, what would the court have said other than what they have said? And any other person, what would they have said other than that?
You are
because it is very simple. The Constitution guarantees that. You see, all that the Electoral Commission is doing, the only way you can actually question their decision is if you are able to establish that their action and conduct contravenes Article 296, the exercise of discretionary power. You know, so if you're able to establish that maybe it's capricious.
So let's take it step by step. Relief 1 was struck out because that one had been abandoned, or like the NDC say, they were compelled to abandon that relief. That relief simply was asking that the Electoral Commission doesn't have power to compile a register after one has already been compiled, but it can only expand upon it.
That was a very interesting one.
Now, so the relief 2, they said, this relief is granted subject to the fact that all eligible voters must make themselves available for registration as directed by the Electoral Commission pursuant to Public Elections Registration of Voters Amendment Regulation 2020 CI 126.
Sure, that is exactly what I have just said. It's granted subject to that, which means that, you see, it was just a declaration and something for the purposes of education. You recall the famous case of Salah and the Attorney General, in which they just sought a declaration, and that was it. They made a declaration. There were no consequential orders to that effect. But if you look at this particular one, they sought a declaration, and the declaration was actually granted. But what is the import of that declaration that they sought? That is what we should ask ourselves. Import of the declaration was to say that A, B, C, D, and the court granted that. But the court granted that and went ahead to say that, yes, now if you want to register, go and subject yourself to the provisions of CI 126. And of course, we all now know what CI 126 contains. So basically, anybody who wanted to comment on this issue and having knowledge of what CI 126 was, and they were subjecting this particular provision to that, could have understood right from the onset that this is what the justices of the Apex Court meant.
So substantially, the Relief 2 was asking that if the EC was going to do a registration or review of the voters' register, a compilation or review of the voters register, it must respect and protect the rights of citizens to vote. And the court said, we agree with you. But of course, the EC must do it with CI 126. Then declaration, the relief 3.
Yes.
That's the second relief they granted. The rest of them, they were denied. The second relief, they were asking for a declaration that upon a true and proper interpretation of the provisions of the Constitution, particularly Article 42, upon the registration and issuance of a voter identification card to a person, that person has an accrued right to vote, which cannot be divested in an arbitrary and capricious manner. They granted this one to, and they said it is pursuant to the prevailing legislation, correct?
Yes, that is so. But something, if you are issued with a voter ID card, you know, at the time of registration, any person or group of persons who think that you are not qualified to be on the register, they are supposed to challenge you, fill a challenge form and go through the processes, so that if the Electoral Commission finds merit in the protest, then they disqualify the person from being an eligible voter. But when a card has been issued to you, you have an accrued right. There's no debate about that. A card has been issued to you, you have an accrued right until otherwise established that maybe the card was acquired by fraud or misrepresentation. You know, so that if you are able to establish that the card was acquired by false misleading statements and etc., then the Electoral Commission can exercise the right to take back that card from you. Otherwise, once you have that card and it's not been challenged, then you have an accrued right.
Okay.
So that declaration was made, and we totally agree with the court to that effect.
So that one, the court said, this relief is granted subject to the voter registration card issued to an eligible voter under the prevailing constitutional instrument CI 126. Now, hold on there. The reason I take you to these two reliefs that were granted was for us to set the basis properly for the point of view that suggests that the court didn't say that the old or the existing voters register ID card should not be used. What do you say? What is your understanding as the NDC of the grant of these two reliefs?
Thank you very much. In respect of those two reliefs, and I'll come to the issue of accrued rights very shortly, because that is very important to us. In respect of those two reliefs, we are judgment creditors, and we are entitled to enforce those against the Electoral Commission, who are, in this case, the judgment debtors. That is the legal implication, and this is incontestable. In Abu Ramadan, number 3, when they went back for clarification, this is how Badegbe GSC, who was on the panel in this NDC versus Attorney General and the EC, this is how he described the plaintiffs in that case. He said, pending before us is an application by the plaintiff's judgment creditors. Remember that the Abu Ramadan plaintiffs had won in Abu Ramadan number 1. They came back to number 2 with respect to the cleaning of the register, and they prevailed. So they were described as plaintiffs' judgment creditors. If the court is bound by its own decision, if he decides that in this case the NDC cannot describe itself as plaintiff judgment creditors, that will have to be explained. However, as far as those two reliefs that were granted are concerned, we are the plaintiff's judgment creditors, and we can enter into execution based upon the orders made by the court. All right. Now, to the
simple language, that means something has been given to you, two reliefs.
Yes.
So you are entitled to insist that they are implemented.
Enforced, that they are implemented. Okay. So
what has been given to you that you think you can implement?
Yes. So our reliefs were a number of building blocks on each other. The first relief, which was abandoned, upon the first day of hearing, was just, to the effect that the power to compile is exhausted upon first compilation, and the EC can now only revise in accordance with law. Something, if you read the language of the Constitution, it says that to compile the voter register, I think Article 45, to compile the voter register, all right, and to revise it from time to time in accordance with law. So the intent of the premise of the Constitution was very clear, that when a register has been compiled, the next thing that you do is to revise it in accordance with law. And the practice and convention of the EC has always been to have an instrument that details how the registration is done. We started with CI 12 in 1992, came to CI 72, and then now CI 91. So the register that we have now has been compiled under CI 91. That is the Public Elections Registration of Voters Regulations, 2012, CI 91. And our position was that once you have compiled a register under CI 91, and that register has not been revoked, because remember that CI 91 revoked the register that was compiled under CI 92 before the register.
Sorry, CI 91 is 2016.
Yes, CI 91
sorry, 2016, Kuku, sorry. You see why you are a good pocket lawyer. You know.
Thank you.
So once that subsisting and valid register is there and you haven't revoked it, you cannot go on to compile a new one. So we wanted to make that case in our first relief. It was abandoned. I mean, upon as being
Techi Benson reinstated it.
They denied it.
To compile
I knew when Techi Benson brought his case, I knew that they were not going to grant that relief because from the way they dealt with ours, it meant that they were not interested in going into that issue of the power to compile and to revise. So, something now we come to the reliefs that have been granted. Relief number 2 is that where you have the power to compile and to revise, you must do so, all right, in accordance with law, and then you have to respect and protect existing voter rights. Now, people do not understand.
You just stated the law, and they agreed with you. Yes, you have stated the law. What the law says.
No.
So
you see, when you are seeking my lecturer of civil procedure, E.D. Combe, always advised me. I was his best student. I actually won his prize in civil procedure. He always told me, Dominic, when you are drafting your reliefs, draft them as closely to the law as possible. Okay, so we drafted these reliefs, as closely as possible to the Constitution. All right, and that is why we said they must do so. And in doing so, they have to respect and protect existing rights to vote. It was intentional. It was meant to, tie the hands of the EC when it comes to the registration exercise. All right, and we elaborated on this in our statement of case. If we have time, I'll tell you what the arguments we made.
But it makes a bit of a difference, doesn't it, when you put in the word existing rights to vote? Because in the relief, you don't actually say existing rights to vote. You say must be exercised subject to respect and the protection of the right to vote.
Yes.
Okay.
All right. So whether it is future rights to vote or current rights to vote, it is of no moment legally.
All right.
Because you see, if you have the right to vote, and that is why Relief 3 is very important, which has accrued, we are saying that it has to be protected in the course of the registration. Protection means you don't disturb the right. You don't take it away in the course of registration.
So you're not talking about Relief 3?
So the reliefs are tied together, they're interrelated. So now let's go to Relief 3. Relief 3 was to the effect that, all right, we wanted a declaration that, in the exercise of their, power to compile and revise, okay, and in accordance with, Articles 51 and 42 of the Constitution, all right.
Upon the registration and the issuance of a voter identification card to a person, that person has an accrued right to vote, which cannot be divested in an arbitrary and capricious manner.
Good.
Is this also not a statement of fact that once I have a right to vote, you can only take it away from a lawful process and not by an arbitrary and capricious manner? They agree with you?
Yeah, they agree with us. But something, that is where the catch is. And that is why we advise the General Secretary, okay, to say that the voter ID card has been included. And I will tell you why. We said so in accordance with legally accepted principles.
Okay.
And
convince us.
So the current Deputy Attorney General has just agreed, all right, that when you are registered, that is when your right to vote accrues. Everybody in this country has a right to vote, guaranteed by Article 42 of the Constitution. And the language of Article 42 is very clear. It says that every citizen of Ghana of 18 years and above, of sound mind, has a right to vote and is entitled to be registered to vote. So when we started in 1992, we all had a right to vote. But until we registered, our right to vote had not accrued.
Right.
It is only upon registration, when you take the step to register, that your right accrues.
Yeah, so they agreed with you and they said once you are registered and you are issued with a card, you have an accrued right.
Yes.
That cannot be taken away from you unless by a lawful means.
Yes.
So go and register.
That is not a language of
they said
in accordance with 126.
They said granted subject to the voter registration card issued to an eligible voter under the prevailing constitutional instrument, CI 126.
Yes.
That's what I'm saying.
Okay.
This one, simply explained, means that yes, go and vote, go and register. You get a card. Once you get that card, no one can take it away from you through a capricious and arbitrary means.
If that is what, I'm yet to see the reasoning of their lordships. But if that is the import of what they have said, then they have stood the principle of accrued rights on its head.
How?
Because you see, when a right has accrued, okay, it is not a right, as we say in law, in the future. It is not a right in futuro. It is a present vested right that can be exercised. And in the context of electoral laws, all right, accrual of your right is proven by evidence of your registration as a voter. And that evidence is your voter ID card. So if you, as a court of law, you accept that under the present law, I have an accrued right to vote, and that accrued right is evidenced by my voter ID card. And you are now telling me that though you have this accrued right, which by all the legal authorities we know, including CFAO and ZACA, you know, Azukrab's decision in that case about retroactive, you know, taking away of accrued rights, that I can now only exercise that right subject to a law that is, you know, a step that I will take in future. Okay, that.
But in your relief, you didn't say they have accrued the right on the basis of their previous registration and their previous card.
No,
you didn't say so.
You see, something in drafting reliefs, okay, yes, there is a certain level of specificity that is required. However, okay, usually you elaborate on your reliefs in your statement of case. And if you read our statement of cases that we filed, we were very, very clear that we are dealing with voter ID cards issued under CI 91. Okay, and the judges cannot have missed the fact that we were talking about accrued rights under CI 91. So for an accrued right under CI 91 to be exercisable in the future under CI 126, okay, is basically to say that you are suspending that right until the person takes a step to register again.
You are saying by doing that, they have turned that principle on its head.
Yes.
And this will be the first time they have done any such thing?
Well, in fact, that's why I'm saying that I'm waiting to see their reason.
I asked so because I wanted to draw your attention to Martin Pebu number 2.
Yes.
Where he went to the court and said there should not be a non-bailable offense.
Yeah.
Every offense must be bailable. The court agreed with him. When they agreed,
they said it would take effect prospectively.
Yes, prospectively.
Yes.
So the people may have gotten that right already because that law was already there.
They are distinguishable.
They are distinguishable?
They are distinguishable in the sense that, you see, when you are talking about bail, okay, a bail application might have been either refused in the past or pending as at the time of the decision. Okay, so the question is whether a bail application that was refused in the past will now automatically be restored and granted. That is a different context altogether, as opposed to saying that from now onwards, all right, you know, you cannot say that there is a non-bailable, I mean, some offenses are non-bailable. So basically, you are directing courts to follow the law as you know, enunciated by the Supreme Court.
All right.
Okay, in respect of, I mean, this in bail. But if you are looking at the context of electoral laws, okay, the accrual of a voter's right is at the point of registration, and once the person has been identified and registered as an eligible voter,
you have made that point very clear.
Yes.
Lawyers and law students are tuning and learning. Let me hear from the dean what he thinks about these two reliefs granted. Did they actually give rise to any confusion, and so the confusion was justified somewhat, even if initially? Mr. Abuchi?
Not at all, in my opinion. I think, again, the arguments that Dr. Ayina is making are absolutely correct as well, that when rights have accrued, you cannot take them away. However, the Supreme Court has inherent jurisdiction under the Constitution, that whenever it makes any decision, it can situate it in context and then give it a consequential effect. In this case, give it a prospective effect as opposed to a retroactive effect. It's important to take the decision as a holistic thing. The court decided that the commission has a right to go about the registration in a particular way, pursuant to the CI. In that respect, the court decided that as the commission is about to start the process, even though rights may have been accrued, those rights will have to be exercised pursuant to the commission's exercise of its powers under the CI.
But that would be subversive of the Constitution. Seriously, Abuchi, no, with all due respect to you, that would be utterly subversive of the Constitution to say that a constitutional right that has accrued, all right, cannot be exercised now, but must be exercised in the future, subject to, you know, 126, and you are invoking the inherent jurisdiction of the Supreme Court to divest Ghanaians of their rights. I mean, that is a really outstanding argument to make.
Okay. If I may, respectfully.
All right.
So I understand your point respectfully, but the point is this: the court has made the decision that it's a structured decision, different layers. So I think maybe we can just. I agree with you that we don't have the benefit of the full reasoning, so it's difficult sometimes to make some of these rationalizations. So more or less, we are second guessing the court. But here's what I think of what the court is saying in light of the summarized decision that has been issued. Number one, the court acknowledged that that people who pass Article 42 test have the right to vote. So once you pass the test under Article 42, you are a citizen, you are 18 years of age, and you're registered. You pass the test to vote. That is a right that would have accrued pursuant to the voter's ID card that may have been issued in the past. The court, however, went ahead to say the commission reserves the discretionary authority pursuant to Article 296 and pursuant to Article 23, to exercise the powers that are vested in the commission under Article 45 in a manner that the commission is structured to exercise. So what the court did is to recognize the right to vote of all persons, of all citizens who pass the test of Article 42, but then to go ahead and say that unless and until you can establish that the commission is expressly violating any aspect of the Constitution, the court actually went ahead to say there will be a presumption of legality. So what the court has done is essentially to vest the commission with the power to exercise these rights with a presumptive regularity, that unless you can establish a clear violation of the Constitution by its actions, the commission will be deemed to be acting properly.
Okay,
now,
so you were agreeing with Dominic on the principle of accrued right, and he insists it must never be prospective, and that this is a sort of a retroactive process. Can you explain how exactly you agree with him and how you disagree with him? Have you ever taught in your class that an accrued right can be prospective rather than something you already have, which must never be taken away from you, regardless of what?
This is not a regular accrued right. There are common law accrued rights. This is a constitutional situation. Now, it's important that we situate things properly. The point I'm making here is that the courts appeared, and again, I'm using appeared advisedly because the court, this is a summarized version. So we haven't seen the reason. What the court has done, it seems to me, is to say that you have the right to vote, Article 42. if you had been a registered voter in the past, so you have the right to vote. Now, the manner of exercising that right moving forward is vested in the administrative discretion to be exercised by the Electoral Commission.
Okay.
The manner of the exercise of that discretion is itself constitutional. We shouldn't forget that. So the manner of exercising that discretion, Article 296, and to a limited degree, Article 23, is itself constitutional.
Right.
Now, in exercising that, so long as we cannot establish a clear case of a violation of the Constitution, the Electoral Commission will be presumed to have been acting properly. Now, nobody should confuse my explanation or attempt to break these down to whether I agree with the decision of the court or otherwise. The point I'm making is to try and explain this, and you were trying to task me to do this on the basis of being a teacher. You haven't paid me for that yet, but that's, clearly just trying to get me to explain in a structured manner. So the point is, the right to vote is not touched. The right to vote remains. However, the nature, the mechanism, and the metrics for exercising that right to vote is one that has been vested in the commission and reiterated by the court.
But you hold on for a second. Dominic is getting back over and again. But I need you to address one simple question.
Yes.
Dominic. The relief says, yes, they should agree that people have an accrued right to vote.
Yes.
Once they have been issued a card, they have registered and issued a card. They say they agree. You say that right cannot be divested in an arbitrary and capricious manner.
Yes.
So is it now your understanding that they are saying, like you seem to agree here, that it can be divested, except that it cannot be divested in arbitrary and capricious manner? So it is being divested, but not in an arbitrary and capricious manner. It is being divested through the lawful process of CI 126.
Well, what is arbitrariness? In the context of Article 296 that Abochi has referred to, what is arbitrariness? Article 296 is very clear. Read with Article 26. Administrative authorities, cannot act, without reasons. Or, as stated in the case of, the Wensbury principle.
Yeah, Wensbury's principle.
That, they should not take a decision that a reasonable person, in their shoes, would not have taken.
I see.
All right. So and you see, I think that Abochi is right in saying we should, not go into the merits because we don't have the full complement of the reasons accorded by the court. All right. But something, just look at it this way. The court, and I think that is what Abochi
just a minute. Do just a minute for me because I need to hear from
others. So the court was saying that, all right, if there is a manner in which, if there are two alternative ways of doing something, and then you are administrative authority, such as the EC, nobody can dictate to you how to do it. But here, we're not dealing with the manner of doing things. We're dealing with existing substantive rights, that we're being threatened by the actions of the Electoral Commission. And we were saying that once you have that accrued right, the Commission cannot take any step that has the effect of divesting you of that right, or taking that right from you. Your point
is that once you have gotten these two, you will go ahead and enforce. How are you going to enforce that? And why are you seeking to look at that oblivious of, for example, reliefs 4 and 8? In your relief 4, you were asking for a declaration that all existing voter ID cards are valid for identifying persons in the exercise of the right to vote. They denied you that. Then in your relief 8, you were emphatic. You say they should make an order the EC that it must include all existing voter ID cards as one of the documents serving as proof of identification. That one too, they refused it.
I thought that was Techimensin. Or is that
no, in yours.
In our rate,
yes.
But
they refused it.
But okay,
So cumulatively, they simply say you can't use the existing voters' ID card.
Well,
and you are still saying you go to 2.
I don't want to say that.
3.
You see, we, as I said, the reliefs were building blocks, and the more general ones preceded the more specific ones. But you would notice that in the specific ones that we sought, we actually asked for declaration of unconstitutionality of 126. All right. And I think the justices walked away from that for obvious practical, administrative, and managerial reasons. Because if 126 had been declared unconstitutional, it would have meant that we're going to restore the status quo ante. All right, we're going back to CI 91, and the Electoral Commission built, its hopes on the register on 126. Okay. So definitely they didn't want to touch 126 in terms of its constitutionality. But having held that there is an accrued right, we are of the view that accrued right is evidenced by the voter's ID card. And therefore the court understood, or should be interpreted to have understood, that the new the existing voter ID card, when issued, cannot be taken away.
In a minute, tell me what you are going to enforce. You said you are judgment creditors, yes, and you are going to enforce the reliefs that were granted you.
Well, if we get the judgment, and that is the reasoning, okay, because we cannot do enforcement.
You get that on the 15th.
On the 15th, but we can, for instance, in the case of Relief 3, okay, enter judgment and serve it on the Electoral Commission, to say that, they must accept the, existing voter ID cards for purposes of registration.
So they will point you to your Relief 4, which was denied.
No, they cannot
Relief
do
8,
so.
which was denied.
They cannot do
and
so.
And the consequential reliefs, particularly consequential reliefs number 1 and 2.
They cannot do so. You know why? Because if we enter judgment issuing from the registry of the Supreme Court, they are under obligation to obey. They cannot be arguing with us about reliefs that were dismissed.
No, they will get back to the court and tell the court that you don't have what you are asking for.
Okay, yes. And in our enforcement action, if they want to contest it, then that is where we will
Thank you. Now hold on there. Now hold on there. Penka, and I'll come to Kuku. Kuku is patiently. Penka, so by your understanding, and I want to lift you to, again, reliefs 4 and 8, and which were denied, and then to the consequential reliefs. Are you in any doubt at all that what Dominic is saying is plausible?
Oh, well, you see, I must be very, very honest with you, Samson. You see, Dominic is my elder brother, and I so much respect him. But you see, the court was very clear and emphatic. You see, when we are educating the public, we should be mindful of what is before us and not what will satisfy us. Because you have read out clearly the 2 dismissed reliefs, 4 and 8, very clear and categorical. You asked that the existing one should be used for purposes of registration under 126. They told you no. So what are you going to enforce? What are you going to enforce as judgment creditor? That general relief that they sought, which was granted as I indicated, was not in dispute anyway. What was in dispute was whether or not the existing voter ID card should be used in registering under CI 126. That was the dispute before the court. That was the issue for resolution, which was dismissed.
Okay.
So what is he going to enforce there?
Yes.
I think that...
and Pekka, just a second. What are you going to enforce when your presidential candidate, your flag bearer, says the ID has been excluded, and so people should just get ready with their passports or their NIA cards or get ready to guarantee for others?
We are not going to enforce based upon President Mahama's statement. Kweku has rightly situated that statement in the political context. In the legal context, there is a concrete relief granted by the Supreme Court. If the Supreme Court refuses to enforce its own order, granting a relief to a party, okay, then it means that the court itself is engaged in self-destruction because his own integrity is going to be questionable.
You are not seeking first to go for clarification like Abu Ramadan and Evans Lemakon did?
Well, when we look at the reasons, we'll advise ourselves.
Okay.
However, if you have a relief, they said granted. So what have they granted?
Okay, thank you. Yes, Kwenka, you were making a point.
Yeah, so it's asking, what have they granted? The flip side is, what have they dismissed? They have dismissed your request for the use of the voter ID as the basis for registration. That's what was dismissed. So it was so clear. So if that was dismissed, I'm asking a fundamental question. What are you going to enforce? You see, there's even no need. For me, there's no need to go for any clarification. So long as the Relief 4 and 8 were dismissed, there's no need to go for any clarification. Because if the Relief 3 answers, as my learned senior want us to believe, answers for Relief 4 and 8, then why were those reliefs there? Why were they seeking Relief 3, 4, and 8 as different reliefs? If the grant of Relief 3 meant a grant of Relief 4 and 8, why would they
read the release very carefully, and you note that we asked for the declaration of unconstitutionality.
Yes.
Of 2126.
Okay.
Yes.
Okay.
So I'm saying
all right.
that.
So
what you are saying, what Dominic is arguing,
right.
He's saying that the grant of Relief 3 meant that they have actually gotten what they were seeking. And I'm saying that if that is what it meant, and if that is what they sought to mean, why were they asking for 4 and 8?
Okay. Now, Dinabochi, was the voter's ID card that I currently hold excluded? And on Tuesday, when I go to the polling station registration center, can I present that from your reading of the decision? Hello, Mr. Abuchi. Yes, Mr. Abuchi, can you hear me? Okay. I understand that you have muted your microphone. If you can take care of it quickly, and I pick your mind on that, then we have our street pocket lawyer sum it up for us. Then we'll bring a certain aspect that we find, particularly in their submissions, suggesting that our voters register has been so bloated, and the only way forward is a fresh start. Hello, Mr. Abuchi. Okay, Kweku, let's hear you.
Lawyers have spoken, coming from a layman's view. See, when I take a look at the reliefs, 4, 5, 6, 7, 8, I see that the attempt or the request to get the old voter ID card used were all denied. From 4 to 8. So explicitly denied. I think what our friends are doing, and I'm choosing my words very carefully in order not to sound offensive. I think it's a very crafty but not too smart way of smuggling what was denied into
certainly not.
Relief 3 that appears to have been granted partially, in my candid opinion, because it was subject to CI 126. That's all our friends are doing. Explicitly, declaration that all existing voter ID cards are valid for identifying persons in the exercise of the right to vote, denied. That is 4. 5, declaration that the new CI's exclusion of existing ID cards as proof of identification is unconstitutional and a nullity, denied. Relief 6, declaration that EC excluding the existing voter ID cards from the proof of identification is arbitrary, etc., denied. Release 7, declaration that proof of identification should not be limited to what the new CI says, denied. Then 8, an order that the EC must include all existing voter ID cards as one of the documents serving as proof of identification. These are very clear substantive denial of usage of the old voter ID card. So what are our friends talking about with relative to relief 3, which says declaration that upon registering and being issued a voter ID card, a person has an accrued right to vote, which cannot be taken away in an arbitrary and capricious manner. What does the court say there? Yes, but subject to a voter ID card issued under the new CI 126. So you can't smuggle all what had been denied into relief 3 and seek to make an advocacy. Okay, I agree. When you turn 18, you have accrued rights, you be constitutionally. No, 18, you have constitutionally eligible to register.
You have the right.
Yes, but the actual exercise of the vote to vote is guided by law.
Okay. Right, so, and let's get Abochi on now. What do you say to the question I asked you? If you went out on Tuesday to any of the registration centers, would you go with your existing voter's ID card? Will you advise anybody to do so, and why not?
Well, this is a problematic thing. And first of all, judicial decisions are to be interpreted by the persons who are affected. And we have a clear case of a controversy brewing here in which there are different interpretations on this. So I foresee the possibility of the parties probably having to go back to the court to ask for an interpretation of whether by the court's decision the voters...
From your reading of the entire decision, is there a need to go back to the court for anything?
Again, from the summary, what Dominic is arguing is an extrapolated position. He's making deductions on the basis of what the court is saying. So on the face of it, the court appears to have rejected a voter's ID card. But he's making a deduction that if the court says that it has accepted some of the positions they advanced, one of which is the fact that you should not deprive it arbitrarily and capriciously. And his reading, or the logical conclusion of his reading, is that once you deny the voter's ID card that has been issued by the commission itself in the past as a basis of identity, that is capricious. It's an extrapolative conclusion that he has made on the basis of the first earlier premises, which is not illogical. It is logically sound. So what that means is that you may have a potential case of interpretation difficulties or controversy, and it may warrant actually going back to court for the court to give a clear direction on the basis of the fact that even though we said X, Y, Z, this is not what we meant, for the parties to be clear on that. I for one, if you ask me, on the basis of the fact that the courts kept referring to the CI and the fact that compliance with the rolling out of the registration should be on the basis of the CI, it does seem that the court may have restricted itself to what the CI is saying. And so then the question is, what is the content of the CI? Okay. But again, as I indicated, it is very easy for parties to disagree on this. And it seems to me that the extrapolations that Dr. Aina is making may just warrant the need for the parties to actually go before the court again for clear directions on the basis of what there is on this moving forward. But if you may allow me just a minute, that a decision of the court may throw out into the political fray larger and more complicated questions than we probably are looking at, especially for the future moving forward. If you have a state institution like the Electoral Commission issuing voters' ID card, and as Dr. Aina mentioned earlier, to be allowed of itself to say that we did not do a good job in the issuance of the voters' ID card. And on the basis of that, we are asking another state institution to authorize us to exclude that. That is empowering an entity to do what lawyers call to approbate and to reprobate. Approbating and reprobating is to say something and to deny the very thing that you said. And it's not allowed in law. It is deemed to be undermining of the very essence of a legal obligation of a person and institution. I think that this is worrying. The fact that we can have a state institution to issue, so as we have the NIA, for example, issuing cards today, potentially we can have the NIA 5-10 years from now, basically saying all the cards they've issued are invalid, and for whatever purposes people can use them, they have to now go through a new process. It's a bit difficult in that regard. The second difficulty I have, and this is my last one, is the issue of the refusal of the amicus. I know that it is a preliminary matter, but the essence of an amicus before a court is supposed to be an aid to the court. Amicus curiae simply means friend of the court. Now, even in the US, where amicus started, the process has been applied in such a manner that a person who is filing an amicus brief must actually state the party on whose side his amicus is likely to aid. And therefore, I find it exceptional that the justices actually thought that an amicus by anybody or entity in Ghana which is being filed in the matter is not neutral enough to be admitted. In fact, neutrality itself is a myth when it comes to amicus. Amicus invariably will aid one party because the court is not supposed to necessarily give a balanced decision or a decision that is both sides. The court will invariably end up giving a decision that supports one side. So if the amicus is helping the court to understand the law or to understand the principles or to avert its mind to something, which invariably would result in a decision being given to one side or the other, I found it very surprising that the court actually rejected the amicus on the basis of the fact that it lacked neutrality. In the country or the US where it originated, it's a partisan thing. It is not designed to be neutral. It is designed that a party should actually state on whose side the amicus is likely to aid. And so in this respect, I find that quite disturbing, particularly because it's going to be a trend moving forward. It means moving forward, if you're going to file an amicus, you have to try and speak for both sides or do not file it. And I think that's a bit troubling.
I see. So how do we answer this other question? On the question of the amicus and not admitting, there are some who suggest that in the election petition case, the law stated in black and white that those to deal with the matter must be an individual citizen, as in Ghanaian, a human being. And yet, the court bent back and admitted the NDC as a party, even though I think Bafuboni and Niyebwa and I think one other, opposed that decision, but the majority won in that case. And the law reporter actually criticized that as a bad decision that the court had made. The suggestion then is that if this is a court that was willing, even in the face of the law, which said you needed an individual human being to be a party, and yet they admitted an inanimate NDC to join, they should have admitted the amicus. But did you hear them ask questions which eventually suggested that the amicus had not been conversant with what was before the court and therefore cannot be adding on to what it didn't know?
Not exactly. Can I answer that question?
Yes, Mr. Abuchi, that's a question to you.
Okay.
Okay, well, I think Dominic is trying to aid me there. I wasn't in court, so I did not have the benefit of the back and forth, the interaction between the courts and the lawyers in terms of the arguments on this. But the jurisprudence of the court is just rife with the fact that the court will admit inanimate persons, the court will admit entities, the court will admit artificial persons, even associations, some of whom are not strictly speaking incorporated. The court has had an open door policy, if you like, in terms of standing.
Okay.
And if you ask me, I think it's even not broad enough. I think the jurisprudence of our courts in Ghana is a bit too narrow, especially being the apex court. The apex court in India operates a very open door policy, and in fact, they have what is called the epistolary process. Under the epistolary process, you don't even need to comply with rules of courts. You don't even need to comply with strict legal procedures. The court will simply ask itself whether you have something before them that demonstrates a complaint, and whether you have a certain degree of standing before them. And the court will allow that. So people write simple letters. I mean, you may have some old lady in the village who has a complaint, a constitutional complaint, and writes a simple letter. A letter which a layman's letter doesn't have a lawyer, doesn't have the benefit of a lawyer, but has sufficient degree of complaint that the court will be ready and willing to hear them, as opposed to all the legal rigmarole. So I think that the court is right and will be right in admitting artificial entities.
There's a substantive question. People are asking, one person can guarantee for 10 people. So either you have your ID, passport, or you have your Ghana card. If you don't, somebody goes to register and they become a registered voter, and then they guarantee for you. Now, I go to register, I become a registered voter, but the process is not complete. Then I guarantee for 10 or 3 people, they also guarantee for several others, and then in the course of the challenge process or the review process and exhibition, my name gets deleted because I may have committed some fraud. what happens to the people I guaranteed for?
Well, big question. I don't think the question has been answered. I don't think the question as to whether a person who guarantees for others and who is subsequently found out not to have even been qualified to guarantee himself, whether the people he may have guaranteed for, whether the guarantee process would have been nullified and therefore the whole process would have had to be started again. There are administrative questions. Look, one difficulty with this whole exercise is the timing factor. We confront multiple challenges. We confront coronavirus or COVID-19. We are living in uncertain times. We have barely 6 months to the election. There's a huge logistical and administrative challenge that the EC will have to confront if this exercise.
It says it is capable, so we give that to them. We says it is capable, so we give that to them. On the questioning of the guarantors. Yes. Now, you would have read the submissions by Godfrey Dame, and in those submissions, you find that at each time when the register is being expanded, yes, the greater number of people that get admitted onto the register are those who are guaranteed for.
Yes.
So what is your fear here? And again, he demonstrates 2012, 2016, and various times up to now, how so bloated the register is.
Okay, so on the question of the guarantee, all right, if that is the process that was used to compile the 2012 register, and that in the case of the EC itself, it says that 95%, about 95% of persons who registered were vouched for or guaranteed for.
So what's your problem?
Okay, I'm taking the fight back to them. It then means that their argument that the register is, defective constitutionally and must be thrown away and for a new one to be made is flawed. Utterly flawed, because if you say that you have statistics showing that 95% of persons, who registered, were guaranteed for, all right, and that the guarantee process was not in any manner or form legally flawed, okay, it means that the register is 95%, credible and valid.
The question of a guarantor who is found to have
to
not be qualified. What happens to the people he has guaranteed for? Can you answer that directly?
Fraud vitiates everything.
Really?
Yes, fraud vitiates everything. Because you see, if someone procures the card fraudulently, and then it is during the process of the adjudication, it is realized that, it is established that they did so fraudulently.
What the person did was just to testify to my citizenship. That's all. But his sins, why should they be transferred to me?
What is the basis of the testimony?
Okay. Kwenka, briefly on this question about what happens to a guarantor who is found later to have not be qualified or have done it fraudulently. What happens to the people that person guaranteed for? That's my last question to you. Yes, Kwenka.
Something, but you know that in law, fraud vitiates everything, isn't it? Fraud vitiates everything in law. So if the product of, a particular thing is fraudulent, then the thing itself is fraudulent. Just as it was argued some time ago, the fruit of a poison tree story. So I can say that if it is established that an incompetent and an unqualified person has gone ahead to guarantee you, then it means that that guarantee is a nullity.
So substantially, if we have over 90% plus who constitute the people on the register being those vouched for, then there will be trouble. You see that?
Then that's something. Why will there not be? How will you, in the first place, determine that you are competent and qualified to guarantee someone? You have to go and make proof of it first.
Okay.
You have to go and prove that you are qualified to guarantee someone. So what you are talking about is most unlikely to happen.
I see.
Otherwise, that would be negligence on the part of the EC. To just let somebody walk there and say, I want to guarantee for Mr. A, and without due diligence and check, you say, go ahead and guarantee.
Okay.
You must first be qualified to guarantee before you are allowed to so do.
Thank you. You have any final comments?
May not arise.
Yeah, Kweku.
Well, it's a good exercise to interrogate, even critique decisions of the judiciary for both academic and intellectual purposes. I think that's a good one. Of course, if you think there's something incurably wrong with the judgment or verdict. We also know there are avenues to cure that mischief. But where we are, my advice to the NDC is to focus on the coming elections.
Okay.
Get their party in good stead. Concentrate, the registration first and foremost. And then, of course, put the party in a state of readiness. That's where they should keep their focus.
All right. But I doubt how you can seek to overturn a unanimous decision of the Supreme Court. We'll take a break here, and please don't forget that we are on the NPP's grounds where the president is being acclaimed, and we will bring you up to speed on those. We'll be right back.
The High Commission of Nigeria further presented receipts of payments on the said land made by bankers' drafts payable to the Executive Secretary of the Lands Commission. However, land title certificates had not been issued to the High Commission. The Lands Commission advised the High Commission of Nigeria to provide relevant documents on ownership of the land, but the former did not respond to the letter. Based on the silence of the High Commission of Nigeria, the Lands Commission went ahead and issued a land title certificate covering the said parcel of land to a third party. The Lands Commission has confirmed, however, that the letter of 7th August 2000 presented by the High Commission of Nigeria granting allocation and right of entry to the High Commission was genuine and indeed emanated from its head office. 7. Unfortunately, owing to the fact that the High Commission, the Nigerian High Commission, did not obtain a lease following the allocation letter or proceed to obtain a land title certificate or even a building permit for the new property that they were building, a search by the Lands Commission did not show that any proper documentation had been obtained in respect of the property, which is why they could not find any documentation on that piece of land. The government of Ghana will ensure that the demolished building is restored to its original state as soon as possible. The Lands Commission will proceed to issue a land title certificate to the High Commission of Nigeria to regularize its ownership of the property in question.
You see the twin bombers or whatever it is already circulating the whole circumference of Ghana. All hell will let loose. If it was UK, the same thing. It was Germany. So I think we should respect ourselves as a country. So thank you, Honourable Minister. The Ghanaians, whether the local chief or the government should understand that because of that proximity, they should give us that respect. Then my question is very close to what Honorable Sada has asked, because this issue of Nigerian traders and everything, everybody is relating it to the issue of closing the border. Now, I'm sure the Honorable Minister would give us a list of, things that we have done to secure that, so that Nigerians will not be put at harm's way. But then, how far have we gone to see that these things have been, strictly been implemented? Because if they are, I don't think the Ghanaians will have the guts of demolishing the building and continue to subject Nigerians to, especially Nigerian traders. I have, friends that are in Ghana. I was going to complain to the chairman when they called this meeting. A number of them are still being harassed, Mr. Minister. They are still being harassed to the extent of following them to their homes. Really. It's not a question of putting a badge to say that I am a foreigner. No, they follow them to their homes. Most of them are helpless. They have succumbed to the pressure from the Ghanaians to the extent that Nigerians are being treated like slaves. This Honorable Minister, please, we have to do something, diplomatically or otherwise. Left alone, and this is my opinion, the Buhari I knew as a uniform man wouldn't have tolerated this. Maybe because of this democracy we are, and now he's a Democrat. If not, my father told me, if somebody slap your friend, if you get there, don't ask questions, slap him back. Let's get a small building that belongs to Ghanaians here. We demolish it. When they ask questions, we tell them it's hoodlums. We are sorry, we will look into it. This is what you do, tit for tat. I'm sure, Mr. Minister, you know this in diplomacy. Sometimes you look the other way around. Let's demolish one small building in Maitama or Asokoro. And when they talk, we say, sorry, it's hoodlums. They are angry because you have touched their brother there. Let's do it. All this grammar of writing letter, it will go because Nigerians were very forgiving people. But if you allow this area, with this lockdown, we have put security in Abuja, Kaduna Highway. We didn't know. They came at night and demolished the ambassador's house. And we look the other way. Thank you very much. Yes.
So if you thought that the Nigerians may have taken this lightly, you were wrong. Those you are listening to were speaking from their august House of Representatives, speaking there and speaking in the manner that, you know, they forget about all the diplomacy that is required to deal with this matter. This matter has become so serious that the president himself, Nana Addo Dankwa Akufo-Addo, has reached out to the Nigerian president. But when they were done discussing and the Nigerians on their side had to issue a statement, if you have seen that statement, read the very final paragraph of it. They are not taking it lightly at all. Start with you, Kweku. We have heard Sami on it quite a bit because he's ranking foreign affairs. What do you think is going on, and what do you think about how we are resolving it vis-a-vis how the posture of the Nigerians is about it?
Look, I'm surprised at what the legislator was saying. He's voting for absolute lawlessness. I'm surprised. I mean, somebody who's been elected to that august house has to be a certain sense of proportion. I can understand. I mean, you are angry because there's been a demolition here of your diplomatic facility. Yes, but you control your anger.
The Speaker of the House said he had also tried to reach out to Michael Quay.
Yeah.
And you check the language, and it doesn't look like they are happy at all.
Yes, yes, I agree. But I think he got it all wrong, you know. But I read something, and I haven't double-checked if it's true. I just saw it this morning. The foreign minister's view on the latest, I don't know if you've seen it, where he makes a concession.
Yeah, it's true, it's authentic.
That, that the Nigerian side itself too had some challenges in the sense of regularizing this facility over the years and all those. So he thought they should also look inward and concede that here and there they had some problems. But that's no excuse for the demolition and the way and manner it was carried out. But I come back, the Lands Commission, I have difficulty with the way our Lands Commission operates. Because you see, apparently this allocation that was done as far back as 7th August 2000, we are now being told that was lodged at the headquarters of the Lands Commission.
As far back as 2000,
7th
this was allocated to the Nigerian High Commission?
Yes.
Right.
It's here, it's dated 7th August 2000. It's titled Allocation and Right of Entry to Accra Osu-Manche Layout, Site for Nigerian High Commission. They effected some payments through a banker's draft, Standard Chartered Bank and all that.
And that's for permission to start construction?
And that construction, from what I've heard, began 2011. apparently they also didn't go for building permits and all that. That's what the foreign minister himself is conceding, that they didn't do those things and all that. But you see, and then the grant, the land certificate, that's the Lands Commission granted Glyco Healthcare Limited this land certificate. This is dated, well, it's signed 5th May 2020.
Yes.
But if you read...
There was a lease the previous year.
Yes, they registered them the first day of September 2018. This is given to, yes, Glyco Health Care Limited on behalf of those who stood. Because that land is vested in the president in trust for those who stood.
Right.
So first of all, there is a certain disharmony, lack of coordination between the headquarters of the Lands Commission and its regional. I don't think this should be happening at all. And then if you look at the 7th August letter, it was given, the allocation was done by the Lands Commission through the Minister of Foreign Affairs, Ghana. My view is that when the regional Lands Commission was doing the checks and the Nigerians were not responding, no response was forthcoming, what stopped them from contacting the Minister of Foreign Affairs? This is a diplomatic mission. So if there's any challenge there, you're having any challenge within the jurisdiction of the Lands Commission in terms of lack of coordination and all the rest, I think a little hint to the Ministry of Foreign Affairs would have helped.
So what we are seeking to do now in trying to quickly regularize all of these processes for the Nigerian High Commission and to get them to restore the building for them, the process of regularizing, because initially they didn't have one document or the other, couldn't that have been done long ago?
Yes, see, but the Nigerians, and that's why I think the Foreign Minister of Nigeria is being a bit candid. It's a letter dated 4th July 2019 from the Greater Accra Regional Lands Officer to the Nigerian Embassy, asking them if they had any a right to the property. If you don't mind, I'll read it because it's important. It says, request for title documents in respect of site at East Ridge, Osumanche layout. Reference is made to the above subject matter with the subject site plan attached for your ease of reference. The subject piece of land falls within an area vested in the state for the trust of Osu Stool and managed by the Lands Commission on behalf of the stool. As the beneficiary stool, the chief of Osu has granted the land to a company, Glyco Health Limited, and the company has subsequently applied for a lease over same at the Lands Commission. As part of considering the application, the Lands Commission conducted an inspection of the site and observed that the embassy has enlisted the services of a private security company, Good Luck Security Service, to protect the said piece of land. The records of the Lands Commission, however, does not reveal any recorded interest in favor of the embassy. We therefore wish to request you to furnish us with any relevant document the embassy has and any comments from the embassy in relation to the subject site within 14 days from the date of this letter to enable us take the appropriate action on the application received from the company. The Lands Commission would advise itself if we do not hear from you by the said time. Counting on your cooperation, thank you, Maxwell Edu Insaf, Regional Lands Officer.
This is the Land Commission writing, and this is the Land Commission that in 2000 had already, allocated this property to the commission and taking money for it.
That's right. That's why I said that discrepancy on our side as Ghanaians also doesn't sound well, but lack of coordination. What kind of system have we put in place relative to Lands Commission, such an important institution of state? So this is not an excuse. The fact that there was not a response is not so much of an excuse for the demolition. And then two, once you realize that this letter was given to the allocation was done for the Nigerians through our Ministry of Foreign Affairs, what stopped the Lands Commission from getting the Ministry of Foreign Affairs involved? Because it's a diplomatic entity you are dealing with. They are being unresponsive. Get the Ministry of Foreign Affairs. It's elementary, in my candid opinion.
Okay, so let's come to the point of a group of people together with bulldozers, whatever, move to this site and do the destruction, the demolition, and the state can claim it is unaware?
Well, it's possible. Not pleasant.
How is that done?
No, it's possible.
They can't understand that.
Yes, and I agree with them if they can't understand that, because it's difficult to appreciate and understand. But these things do happen, and they've been happening in this country occasionally. You know, the news item that Joy FM put out, the Nigerian, and I don't know his name, but he appeared to be the spokesperson on the scene at that moment. He made a point about an armed man, a person, one person with a pistol, who claimed that he had a backing of national security. Well, this is subject to verification. The two persons who have been arrested, I don't know if they belong to national security. They could be rogue elements. There is no situation, I have no evidence, and all my checks point to the fact that national security officially did not supervise the demolition. That's my information.
No, but this is the national security of Ghana that we know has been associated, rightly or wrongly, with similar such stuff previously.
Yeah, I would rather
except that often there is a denial that people can't believe.
Well, you see, it's very difficult to go along this line, but I would say there are rogue elements in all institutions of states. Some of them, and don't forget the Osu stool, Paramount stool. Apparently they are divided, because there's another counter statement from a faction that disassociating themselves from the demolition. But the first statement from that one side appears to endorse it. It's possible for them to get either land guards or even some rogue elements in the national security who had no permission to undertake that exercise to back them. I'm being speculative here and cautious because I have no real facts to that effect. What I checked with national security hierarchy was that no, we are not involved. We had nothing to do with it. And then when you look at the recording you put out there, the gentleman who was speaking on behalf of the Nigerian embassy pointed to a person who had a pistol and who claimed they had the national security backing. I can't take that on its face value.
Okay.
You have to subject that to some critical analysis.
Okay.
But bottom line, it's an international embarrassment.
Right.
Either way.
So solution is found. We'll regularize the documentation and then we'll build the
apparently they'll be giving a new title to the Glyco people, and we are taking the expense. But I think that eventually those who did the demolition should be surcharged for the expenditure.
Is it good that the state is not disclosing to us the people that have been arrested allegedly, who are supposed to face?
No, they must, because that is what will help to take away all the suspicions and conjectures and
You are the
analysis.
ranking member on Foreign Affairs. What do you have to say about how this has happened and how it can be resolved? And the Nigerian Foreign Affairs Ministry statement, the last paragraph I referred to, they said, after they say the president has been informed and they have spoken with President Akufo-Addo, they say the ministry wishes to call on all Nigerians home and abroad to remain calm despite the highly provocative attack on the High Commission of Nigeria in Accra, Ghana, and to reassure Nigerians that the federal government is engaging the Ghanaian authorities at the highest level to seek redress.
First of all, Samson, let me say good morning to you, to Mr. Abdul Malik Kwekubaku Jr., and to congratulate him on his major victory at the courts. I followed that case keenly, and I think that it's important that in public discourse we all try to be factual and to be fair to the reputations of persons. So it's a welcome victory. Let me also extend my regards to all our listeners and viewers across the globe. Samson, this is a very sensitive matter and a volatile one at that. And we have taken the view as a party and as a minority in parliament that we would not do anything that will stoke the embers, that will, as it were, exacerbate an already precarious situation. And so we have taken the position that we will be very measured and we will put the country first because we are guided by history. These are matters that, if not well managed and well articulated, and we don't put the national interests ahead of partisan opportunistic benefits, we could be up in flames. Yeah. And so we want to appeal to all sides that this is a time to beat swords into plowshares. We should not lift up arms. My colleague legislator in the House of Representatives, whose audio you just played, I won't use strong words. I'll just say that there's a lot of anger, but we can all be measured.
Statements like that could trigger their own people.
Exactly.
And to go set places on
Exactly. I mean, they have had to, and our committee, the Foreign Affairs Committee and the Defense and Interior Committee, we've taken this matter up strongly. We've met with the ministry, we've gone to the site to visit, we've also engaged Nigerian High Commission officials. And what is emerging is that the Nigerian state, because of statements like this, have had to beef up security at all Ghanaian installations.
That's good.
In Nigeria.
But do you realize that their anger is not to this issue only, but to Nigerian traders in Ghana?
And I'm surprised that they do not balance that anger by recalling that we also have serious issues with the closure of their border, which has left businesses like Casapreco and many other traders. You've heard Guta members, complain. Right. So we also have legitimate concern about that, unannounced, very abrupt closure of the border in violation of ECOWAS protocols of integration and all of that. And yet we have been handling the matter behind the scenes. I know of efforts that the Foreign Ministry, the President of the Republic, even our committee have carried out behind the scenes using diplomatic channels to get Nigeria to reconsider its position on the closure of borders, which has brought considerable distress. So yes, we have a lot of issues that we must iron out. And it is the reason why we should be very, very careful, because all it takes is a trigger. If you do not manage these matters well, you have Nigerian shops closed for 8 months. It's unfortunate. I think that in the spirit of even the Africa Continental Free Trade Area, which Ghana hosts the Secretariat proudly, and in Nkrumah vision, we should be looking at how to open up, fully integrate, and allow Africans to trade amongst themselves. If you look at intra-African trade, which is still hovering around 16%, it's woefully inadequate. You cannot develop and transform your economies with the level of intra-African trade, which is the lowest amongst the continents, if you look at Europe, Asia, and others. So back to this issue.
Yeah, we don't have much time, so I want you to zero in on our resolution approach, including why we are not disclosing the people that we say we have arrested and are going to prosecute.
And publishing the committee's report.
You see, there are so many concerns that we have as a minority. First of all, we are of the view that the initial reaction, the statement that was put out, if you look at the 20th June Ministry of Foreign Affairs and Regional Integration statement, where they said unidentified persons, and then they said an alleged demolition. We thought that statement was not the best at all. We should have been more proactive, especially when at that time, the Nigerian Foreign Minister, Geoffrey Onyama, had put out very angry tweets and had called the attacks criminal and that Nigeria demands answers. That was not the time. When we knew at the time the Osu Traditional Council was even already, taking responsibility, our government should have been more open. So that's one. Two, we said that the investigative process should be independent. Don't do it in-house, behind the scenes. That will not inspire confidence. 3, the report ought to be published. 4, the persons that you have arrested, you need to disclose their identity.
Okay.
Because, you see, there is a need to build bridges. And look, if you look at
the non-disclosure and non-identification of these people, does it feed into the suspicion of a state act, that what has happened is perpetrated by the state?
Look, let's be very frank. You cannot entirely delink the state from this matter. The Lands Commission has a lot of questions to answer. We are really competent. The work we have done so far at the level of our committee, the Lands Commission has not held matters. The Foreign Ministry has not been proactive. If you look at the obligations of our country under the Vienna Convention on Diplomatic Relations 1961 and the Vienna Convention on Consular Relations 1963, Ghana ought to have been facilitating all of this. As I speak to you, the Foreign Ministry is facilitating new mission establishment for Suriname, Kenya, and Rwanda. And as is expected, because it will be an invasion if you say you want to open a mission in another country, and so you just get there and you are dealing with the Lands Commission directly. You do it with the Foreign Ministry. There's a Foreign Ministry that grants you access and that facilitates everything. Where was our Foreign Ministry all these years? So there is some dereliction. The Nigerian High Commission should not have been dealing with the Lands Commission directly on the blind side of the, Foreign Ministry.
You will admit, though, that our Foreign Minister, Shelia Ekobote, has been upfront and appears to be on the beat and doing things in a manner with a certain temperament that's very helpful to us.
I think so.
No doubt, but belated. I am saying that all of this could have been prevented. Look, Ghana now has 66 diplomatic missions established in Ghana, you know, and some 38 honorary consulates. Now, I can tell you that there is considerable disquiet and concern within the diplomatic community about what has happened. If we had gone about embarking on our obligations under all these international treaties, which Article 40C of our Constitution obliges us to do, in our dealings with other countries, in the pursuit of international relations. Article 40 is very clear. We should not have allowed the Nigerians to be dealing on their own with the Lands Commission. Then you have other entities, Usu Traditional Council, Glyco Health, and all of it. It was a messy situation. So it's as though
sorry,
we
hold it
created...
on there. President Akufo-Addo is speaking. We listen to him briefly, and then we return. Kofi Abuchi is on the line. Also, Pemka is on the line.
Vice President, Second Lady, our dynamic Samira, President Kufuor, Chairman, General Secretary, Chairman of the Council of Elders, Majority Leader in Parliament, members of the National Council, officials of the New Patriotic Party, officials of the Electoral Commission. I thank Almighty God for the honor done me today by you, members of the National Council of the New Patriotic Party, acclaiming me as the presidential candidate of the party for the 7th December 2020 general elections. I shall, with God's help, do everything in my power to justify your decision and lead this most deserving party to another victory in December. I accept in all humility your decision. The rules of the Electoral Commission and the Constitution of the Republic require that at the time of filing my nomination, I should indicate the identity of my running mate, who, if God permits, will be the Vice President of the Republic. The Constitution of our party provides in Article 13(3) that the Vice Presidential candidate shall be selected upon the nomination of the presidential candidate in consultation with the National Council. So today, I have the great honor to put into consultation with you, the members of the National Council, my choice of running mate for the 4th time, the excellent, hard-working Vice President. Alhaji Muhammadu Bawumia. With your endorsement, the party will complete its presidential ticket a feat that appears to elude some of our opponents. We have no such difficulty. We have a most fitting person to feature on our ticket. And I give you Mr. Digital. Mr. You and I were not there. The economic prophet, the Adam Smith of Wale Wale, my good and loyal friend, Alhaji Muhammadu Wahba Umia.
Right, so His Excellency the President, Nana Addo Dankwa Akufo-Addo, there having been acclaimed by the highest decision-making body of the party to be the party's flag bearer for the 2020 elections in December. And he has accordingly repeated that he has Vice President Dr. Mahmoud Bawumia as his vice presidential candidate, so to speak. So clearly, there's a message that he's sending out, and he even added, without leaving it veiled, that the NDC appears to be in a difficulty producing a running mate. Let's see how that goes. Yes, Koku, what do you make of this?
To be expected.
Right.
We in the season for these things. And it was the politician and the president that was talking relative to, you know, getting his partisans agitated. I mean, that's excited and motivated and mobilized. So it's routine.
Okay.
Yeah.
So the straight question to you is, what's going on? You can't seem to produce a running mate.
No, that's not true. Our flag bearer, President Mahama, has said that he knows his running mate. We're following a timetable. Remember that our campaign team is yet to be put out. He will make that announcement soon, and then he will announce the running mate. He is giving timelines. He said by end of this month. I mean, when Nana Addo Dankwa Akufo-Addo, as he was then as flag bearer, he named his running mate on the 14th of August. You know, we are nowhere near August. That's in 2008. So it's you know, the tradition is that when you are incumbent, it's automatic. Or if you drop your running mate, then it portends crisis. Like you saw the situation with Accra, it means something is wrong. You know, so it's always a smooth transition. You know, if you look at the case of Ali Mahama, the case of Atamil's John Dramani Mahama as vice president. So I think that also this job is quite misplaced.
And something different you can observe with this particular organization, contrary to what happened at some of the places for the primaries, is that you see that people are in their face masks, and some actually have a double protection. They have the face mask and then they have a face shield as well. A few of them have only a face shield. And as the doctors, and including a very good friend of mine, a doctor who just sent me some advice whilst we're on this show from the Kofanochi Teaching Hospital, is that the face shield is not the best of protection, so to speak, particularly where when you're in an inner place like this, you need the face mask rather. But if you want, you have this as a double protection, because we are not in an open space. So for those of them who are there and dancing to music and have only a face shield, that may not be the best protection in the COVID times. Okay, now let's return to our issue, and let me get Panka. Hello.
Put your hands together, ladies and gentlemen.
Hello, Panka. Okay. Yes. Thank you. Dinabochi is still on. So maybe we have you briefly on this issue of the acclamation that is done. It's routine. It's a ritual that ought to be done. It actually ought to have been done in a different circumstance, but because of the COVID, we understand the you know, they have allowed for the highest decision-making body in a certain way to take the powers to acclaim the president, rather than having, it would have normally been done last Saturday when the primaries were going all across the country. Then people would have actually indicated their preference for him by way of acclamation.
Yes, hello, Samson.
Yes, I can hear you clearly.
Is there a question to that?
Yeah, so because of COVID, it's okay to sort of, as it were, abridge the constitutional provision and go ahead and let a few people do what, you know, a crowd ought to do.
Well, I haven't read the Constitution, so I can't really pretend to know, but it's entirely dependent on whether the Constitution allows this, whether the Constitution allows this in emergency times. If the Constitution does allow it, then it's done. But if the Constitution doesn't allow it, you may always have a troublemaker somewhere one day wanting to take this out. And that's always a sovereign difficulty or danger that you face. So if the Constitution allows it, then there's nothing to talk about. But if the Constitution doesn't, and it's just an emergency improvisation, then you always have that question mark at the background in terms of someone one day waking up and challenging the process. So
for the political parties, particularly for the NDC and the NPP, they have this omnibus provision that allows the highest decision-making body to do almost everything, you know, so that in certain circumstances they become the law, so to speak. So they do whatever it's necessary to be done.
Right. So if you have the Constitution framed in those terms, that the highest decision body has the power to undertake acts or make such decisions as are necessary for the smooth running of the party from time to time. Once you have this general framing or phraseology as far as the Constitution is concerned, then of course it's allowed.
All right.
So I do not have the benefit of those provisions, so I can't really comment in detail. But once it's allowed, that's it.
Right.
But if it's allowed, there's nothing to be
Penka, are you able to assist us the specific provisions of your Constitution from where the mandate is drawn to do this instead of having the delegates do it? Okay, let's hear Vice President first.
John Ajekum Kufuor, the First Lady, Mrs. Rebecca Kufuado, Second Lady, my dear Samira Baumia, members of the National Council, members of the Council of State, Chief of Staff, Senior Minister, Ministers of State, Members of Parliament, Chairman and members of the Council of Elders, national, regional, constituency, and polling station executives who may be listening, rank and file of the Kukrudu family, members of the media, fellow Ghanaians, ladies and gentlemen, Salamu Alaikum. I thank the Almighty God for this historic day. I want to express my profound gratitude and appreciation to His Excellency the President, Nana Addo Dankwa Akufo-Addo, for the honor of reaching out again to select me for the 4th time to serve as his running mate. His running mate, and inshallah, the next Vice President of the Republic in 2021. This day is historic because it has never happened before in the history of our country that a presidential candidate will select the same running mate 4 times in a row. That's never happened before. His Excellency the President selected me in 2008 against all odds. In 2012, in 2016, and now in 2020. Ladies and gentlemen, this tells you about the man Nana Addo Dankwa Akufo-Addo that I have come to know over the last few years. He is a strong leader. He's a caring leader, a God-fearing leader, a trustworthy leader, and a consistent leader. He could have dropped me in 2012, and he could have dropped me in 2016, but he stuck with me, and I am so honored that he did, and I am eternally grateful. Mr. President, I'll never take the trust and loyalty you have reposed in me for granted, and I'll continue to do everything in my capacity to support you in the execution of your mandate as President. Sir, it has been a privilege and an honor working for you, and I thank you for giving me the opportunity. God bless you. Mr. President, you have chosen me for the 4th time, and inshallah, the people of Ghana will give you 4 more years to do more for Ghanaians. Furthermore, I wish to express my heartfelt gratitude to the members of the National Executive Committee and the National Council of our party. I thank them most sincerely for their overwhelming endorsement of my nomination. What can I say more in appreciation to all members and sympathizers of the New Patriotic Party from polling station through constituency to regional and national level. You have loved me, you've cared for me, you've appreciated me, and I say God bless you all. I stand here today because of the sacrifices of my family, my parents, the love of my dear wife Samira, my children, my brothers and sisters, my departed dear friend Kwabena Boydu, and my entire family. I thank you all very much. As a believer in and practitioner of the liberal democratic values and principles of the Dankwa Dombo Buzia tradition, like all of you here, I have been inspired throughout my life by the thinking and deeds, sacrifices and accomplishments of such great political icons of our country and party, such as Dr. J.B. Dankwa, Chief S.D. Dombo, Edward Akufo-Addo, William Oforiatta, Alhaji Yakubu Tali Tolona, Upechibi Lampe, Professor K. Buzia, Jato Kalio, Naba Ifa Kabo, Alhaji Aliu Mahama, C.K. Tedam, S.G. Anto, Alberta Jude Boahing, Araram Ponsa, J.B. Darocha, Hawa Yakubu, Gladys Asma, J.H. Mensah, and our own gentle giant, the great J.A. Kufuor. I'm so indebted to so many men and women who have sacrificed and continue to sacrifice for our party and our country on a daily basis without reward or recognition. Mr. Chairman, it is our collective responsibility as members of the great Kukurudu family and as Ghanaians to ensure that the sacrifices of these great men and women have not been in vain. I'm therefore acutely aware of the sacred responsibility that has once again been entrusted in me by the President, Nana Addo Dankwa Akufo-Addo, and our great party. It is a responsibility I will execute with utmost integrity, respect for our elders, members of our party, and members of other political parties. Mr. Chairman, I associate myself with the view of my boss, President Nana Addo Dankwa Akufo-Addo, that politics is a call to service. It is about serving your country and delivering concrete results that improve on the welfare of your fellow citizens, without selfishness, dedication, honesty, transparency, and with the utmost integrity. I believe that an opportunity to serve Ghana is an opportunity and a privilege to serve all Ghana, regardless of ethnicity, gender, religion, education, income, and so on. It is in this context, ladies and gentlemen, that the policies of the New Patriotic Party, as implemented under the leadership of Nana Addo Dankwa Akufo-Addo, should be analyzed. We have delivered and are delivering on at least 78% of the promises we made to the people of Ghana and across the spectrum of economic and social policies. We have not only delivered on our promises, we have performed much better than the incompetent alternative. Much, much better. They say we have short memories, but I don't think you can say that about the elephant. We recall that 8 years in office, after 8 years in office, the result of their economic mismanagement was declining growth, high and constantly rising inflation, rapidly depreciating currency, loss of business confidence, high unemployment, poorly regulated financial services sector, a collapsing NHIS, no ambulance system to speak about, this doomsaw, 45% average annual increase in electricity prices, increases in taxes, the freeze on public recruitment, cuts in research allowances, termination of teachers and nursing training allowance, teachers arrears paid only 3 months after working for many years, corrupt practices associated with acquisition of passports, driver's licenses, and so on. Finally, they ended up with the IMF for a bailout. Notwithstanding this abysmal performance in office, they are still trying to make a comeback to give us an additional dose of their incompetence. Mr. Chairman, I know they don't read, but I entreat them to take a look at the data to get better informed on our performance vis-à-vis theirs. They should not only read the data, but they should try to understand it so that they don't mislead Ghanaians like their mosquito general tried to do after the verdict of the Supreme Court on Thursday. If they study the data, they would realize that for our first term in office, we have not just performed better, but we have performed overwhelmingly better across the board. Mr. Chairman, any claim to better management of the economy must ultimately reflect in the lives of the people. How have we been able to reduce the suffering of our people and make life easier for them after 3.5 years in office? That is exactly what President Nana Akufo-Addo has done. We have ended the suffering associated with doomsaw. We have reduced electricity tariffs by 10.9% compared to a cumulative increase of 264% under the NDC. And we have further reduced tariffs by 50% for the months of April, May, and June this year. We provided free water for households in April, May, and June. Petroleum prices have increased by half the rate that they did under the NDC. We have doubled the capitation grant, established NAPCO, created jobs, and stopped the freeze on recruitment in the public sector. We've recruited over 550,000 people. We've abolished fees for postgraduate medical training, increased the share of the District Assembly Common Fund to the disabled. We've exempted KIA from market tolls. We've ensured the implementation of our promise to employ 50% of the persons who manage the country's toll booths from amongst persons with disabilities. We've restored the teacher training allowance, restored the nursing training allowance, restored the book and research allowance. We are paying professional allowances to teachers. The 3-month arrears policy, salary arrears policy for teachers has been abolished. We are absorbing the cost of BEC and WACSI exam registrations. We've sent 40 students from our Zongo and inner city communities on scholarship to Cuba to study medicine. We've abolished 15 taxes, including including taxes on financial services, real estate, airline, and so on. We've reduced import duties by 50% generally and 30% on cars. We've made it easier through digitization to apply for a passport, to apply for a driver's license, to obtain your pension when you retire, to buy electricity through the ECG app. We've made it easier to apply for scholarships. We've made it easier to send money and receive money from people through mobile money interoperability. We've made it easier to renew your NHIS membership, to register a business, and we have reduced the corruption associated with obtaining services from the public service. We've saved the NHIS from collapse. We are providing 600 million Ghana cedis to small businesses. We've made seeds and fertilizers and extension services available to farmers. Whilst reducing inflation and reducing interest rates, we've halved the depreciation of the cedi. We've paid allowances to UN personnel, increase from military and police from $31 to $35, and we have spent over 15 billion Ghana cedis to save the deposits of the people whose banks were collapsing. 15 billion Ghana cedis. Last but not the least, we have implemented the free SHS policy that they said we couldn't do. Mr. Chairman, we have been able to do all this because under the visionary and strong leadership of the President, we have managed the economy much better. After 8 years in government, the NDC economy could not afford to pay teacher training allowances of just 60 million Ghana cedis. That economy, it could not afford to pay. So they had to cancel the teacher training allowance. In our first year in government, we restored these allowances, reduced and abolished 15 taxes, implemented the free SHS. In fact, by 2019, free SHS, NAPCO, the tax decisions, the tax deductions, teacher and nursing training allowances, and the cost of cleaning up the financial sector mess that we inherited was a total of 20.14 billion Ghana cedis. 20.14 billion Ghana cedis. So how can an economy that could not afford 60 million Ghana cedis on teacher training allowances be able to undertake an additional 20 billion Ghana cedis expenditure in just 3 years? This is why the NDC never believed that free SHS, which is costing us over 2 billion Ghana cedis annually, was possible immediately. We made it possible, and the difference is the competence of the economic management under the strong and decisive leadership of President Nana Addo Dankwa Akufo-Addo. Ladies and gentlemen, it is therefore important that we stay the course and not play chaskele with the economy. Incompetent economic management has major consequences. The money we used to clean up the financial sector, over 15 billion Ghana cedis, and to pay the excess capacity charges from the power purchase agreements that the NDC entered into, could have been used to do much more. Mr. Chairman, we have done a lot in the last 3.5 years, but there is a lot more to do to realize the vision of the President, Nana Addo Dankwa Akufo-Addo. The goal, as set out by the President, is a Ghana beyond aid. It is to build a modern, prosperous, and self-reliant nation which leaves no one behind. We have started putting in place the building blocks and systems. Economies work when systems and institutions work. We want to move away from the discretion of individuals to the efficiency of systems and institutions. Economies that depend on the discretion of individuals to get things done are generally inefficient and breed corruption. taking such an interest in digitization? The answer is simple. We are thinking about the future, and digitization holds the key to the future in boosting economic growth, efficiency of service delivery in the public sector, reduction in corruption, transparency, and accountability. As an economist, I understand that there are certain key systems and institutions that have to be in place for effective monetary and fiscal policy. These include a unique identification system, an address system, and financial inclusion, and an efficient public sector delivery. The application of technology through digitization is going to help us put all these systems and institutions in place. Digitization is the best way to protect the poor and the underprivileged and to have who have no connections. With digitization, I can renew my NHIS membership on my mobile phone or apply for my passport online. I don't have to know anybody. With digitization, government revenues will increase several fold. You will not have to pay a bribe to get a driver's license or a birth certificate. The implications of digitization for the economy are phenomenal.
Welcome back from the NPP's acclamation process that's just happened, and Dr. Bawumia now speaking after the president named him again to be his running mate. JoyNews will continue to bring you everything else that is happening and has happened on the NPP's acclamation grounds at the Lisa Hotel, Swiss Spirit at Lisa Hotel. Let's get back to the studio here and try and finish up the discussion that we are having. And Kwenka, if you are there, I just needed you to give us, assist us with a little clarity on the provision that allows your party to abridge the acclamation process. Instead of having it being done by the delegates, you have an executive arm of the party doing so.
Let me be very clear and emphatic that when you go through the Constitution, you are not implicitly going to see a provision that says that National Council should go ahead and do what has been done now, if that is what you are looking for. But the thing is that the National Council is a representative body of the party across the country, the length and breadth of the country. And you know, we are running a representative democracy. For example, each of the regions is represented at National Council by the regional chairman and then a regional rep who is elected by the party at that level to represent that region. So if you like, all the regions are represented proportionally in this meeting. And these representatives who represent the people on the ground have their mandate to take decisions on their behalf, as Parliament has the mandate of the people of Ghana to take decisions on behalf of the various constituencies. So National Council, which is representative of the various party structures across the country from the grassroots level to the highest, has the power and mandate of the people to act for and on behalf of the party. It is the highest decision-making body. So to that extent, it has the power to act the way they are acting now.
All right. But why is it that the president and his handlers, so far, people have been asking that when he's in public, they want to see him in face mask because he must be the first point of example. You find that he may have it, but he puts it down before he speaks.
I saw him wearing it just right now.
And the vice president too was not wearing it whilst he took the podium to speak.
I think they were wearing it. It was just when he was going to speak that he took it off, but they were both wearing it. I saw both the president and the vice wearing it.
The law does not make exemption for that, does it?
Something, you see, that is another issue that we will need to actually look at critically at a later period. You know, you raised it earlier today And I heard you raise it in clear terms about leaving your house and returning to your house and going to a public place, and etc. That is going to be the subject of another debate another day if you want us to do an engagement. But what I'm saying is that basically the direct answer to your question you asked earlier is that the National Council has the power to
all right, and on that note, let me give this education coming from Dr. Oheniba Owusu-Danso, who is the CEO of the Konfanoche Teaching Hospital. His advice is that never think that the face shield is supposed to be a replacement for the face mask. You need the face mask, more importantly, where social distancing is not sufficient enough and you are in an enclosed place like we are. And so let's pay attention to that, because even in some situations, as he advises, they add the face shield to the face mask. But if you are in an open place, not enclosed like we are, and the social distancing is sufficient enough, then you may use the face shield, because the law actually says you use a face mask, you use a face shield, or you use a face covering. But the most important thing for all of us to note is that you need to protect yourself and protect others by protecting yourself. Let's not forget to keep to all of these. Right, so we will continue with our discussion, and we want to hear from Kwenka and Ms. Abuchi about the diplomatic situation between Ghana and Nigeria, how we can have a resolution that is lasting. Meanwhile, at 12:30, you will meet Odate Lante, ex-Ghana International, on Joy Sports Link with Nathaniel Atto. Yes, Kwenka, let's hear you. Hello, Kwenka.
Yes.
Yes. How do we get a lasting solution and avoid this international embarrassment?
Well, thank you very much. I have listened carefully to your panelists in the studio, specifically the Honorable Okujete Blackwire, and then my very respected elder brother Kwikubako. I've listened to them. I think that we're getting to a stage where there will have to be a committee of eminent persons from both states to engage at the highest level and then put these issues to rest once and for all. You realize that His Excellency the President and the Foreign Minister have taken decisive actions since the outset of these issues, and they have taken very, very firm and decisive issues to have resolution to the matter in order for the two countries to continue to coexist peacefully. But I will say that the government will elevate it to the highest level and ensure that the right things are done, and the right things are only going to be done if we engage each other in dialogue over the period to ensure that some of these nagging issues that have the potential of derailing the good relationship between these countries are looked at critically, and then the consensus arrived at so as to allow us to continue with our daily duties in these two countries without any friction. Yes, leadership is very important. His Excellency the President is providing just that, and is assisted ably by the Foreign Minister. And I believe that these issues will become things of the past soonest.
What do you have to say about what is going on and how we can avoid it and also resolve it permanently? Yes, Mr. Abuchi, my question is, how do we avoid this kind of occurrence and embarrassment?
Well, as I indicated, what we need to do now, it has already happened. So what we need to do now is to move quickly, I think, as the government is doing. I'm quite delighted to see there's a bipartisan approach to this so that we do not politicize it, since this is a very delicate and sensitive matter, so that the various aspects and the kinds of things that we say can further exacerbate things. So I think what we need to do is to really have a high-level intervention, and I'm glad that the two governments are talking at the very highest level, because these are very sensitive things. And there are many records of attacks on embassies across the world that have led to dangerous consequences, escalations between the two countries that cannot be contemplated. So I think that what we need to do moving forward is to ensure that the two governments talk at the highest level. And I think that's what's mentioned earlier. There's the need for government to be involved in the settlement of diplomats and of embassies and of missions. And it's imperative that missions also coming to the country should engage government in their commercial dealings. Because while there is diplomatic immunity for all kinds of things, when it comes to commercial dealings, embassies are actually on their own. They're just like private citizens. So to avoid some of these things and not knowing the complications of the terrains in different countries like Ghana is, it's imperative that when they go into countries, in their entries and settlements, they engage governments to ensure that the appropriate processes are gone through and that they navigate some of these difficult and complex social and legal dynamics of different countries.
Okay.
Our launch situation is a mess, and we all know it. And if they had engaged government properly for their settlement, I'm sure this would have happened. Right. So moving forward, it's important that they engage appropriately and properly speaking.
Thank you very much for your patience, gentlemen. We have less than 4 minutes to go. I don't know if you can spend just a minute to say something about the primaries of the NPP, particularly that 41 MPs, sitting MPs, majority of them leaders of various committees in the House have lost the opportunity to return to the House, and whether that has any implications for the party going forward. Yes, Mr. Abuchi first. Okay. Yes, Panka, what do you have to say about that? You were fortunate enough. You didn't get to be contested.
Yeah, something. Thank you very much. You see, it's really a very, very serious issue that the party needs to look at going forward. Because, you see, I have always been on the floor of Parliament for deliberations all these years, and I have observed critically that those who participate actively on the floor of Parliament, unfortunately, those people do not have the opportunity to regularly interact with their people back home. For example, if you look at the chairman of the Constitutional, Legal and Parliamentary Affairs Committee, the chairman of the Finance Committee, and other such like positions, they are always on the floor of Parliament. And as a result of that, they are unable to reach out to their people regularly. And you realize that they are the people who lost. The Finance Committee chair lost, the Constitutional, Legal and Parliamentary Committee chair lost, and then the Honorable Senator Kwame Champong to another sensitive committee, he also lost.
Or they didn't also because they didn't have enough money and couldn't pay. Because as we understand, like one professor says, this was an auction sale rather than a primary.
Oh, I don't think so necessarily. Even though in some cases, yes, money influenced, but in other cases too, some of the people took into consideration the fact that. I mean, the people were not regular at home. If you look at, let me take a look at Koforidua, for example.
Okay.
I don't know. I have no idea how much any of them paid, but I think that the Honorable Asibe was certainly will have a deeper pocket than Besi.
All right. I'm sorry, but we can't continue. Thank you very much. I'm sure we can have this debate later, particularly that the president has just been acclaimed. Mr. Kujeto, just a minute. What do you have to say?
Well, I mean, let me wrap up on the Ghana-Nigeria diplomatic.
Okay, then that's the only thing you can comment about in a minute.
Let's learn from history. There are ways that these matters can simmer for a long time. On the surface, you think you have resolved it, but you have not. You recall the aliens compliance led to Ghana must go 1983, over 1 million Ghanaians deported. The Susudis affair in 1985. The next year, U.S. was withdrawing aid to Ghana, the Nobisto affair. So let's be guided. The Lance Corporal Jiwa coup staged from Lome, it strained relations between Togo and Ghana for decades until we got into the President Kufuor era and his good neighborliness, agenda appeared to have, addressed that issue, but they are still undertones. So these are matters that you must take very seriously, pursue rapprochement in a way that is genuine and sincere, and let's be transparent about it. Right. National security should also learn lessons and be more proactive.
Thank you.
But I wish I could have commented on the vice president.
30 seconds.
The vice president should appreciate that. Look, Ghanaians have moved away from the politics of name calling, of insults, and incorrigible distortion of facts.
Did he insult
yes,
anybody?
It's language. It's, as
what do you say?
Your high office, you're occupying the vice presidential position. This is the incompetent lot and all of those things. And the continuous distortions. Book and research allowance was not cancelled. That is a blatant falsehood.
You sought to consolidate it into a fund.
Yes.
Okay.
Yes. But it was not cancelled. We were still paid.
Thank you.
This, the 550,000 jobs in the public sector. We still have less than 700,000
The last minute is for Kuku. Sorry.
But we'll resolve.
The last minute is for Kuku.
The scorecard is 14%.
Something,
and
sorry.
not 78%.
Yes. The last minute
I'm
is for
sure
you.
we'll have time to deal with this.
The investigative committee's report, the demolition thing must be made public.
All right. That's all. Okay, so we have just run out of time. The next show is Nathaniel Atto. He comes up with Odate Lamte, ex-Ghanaian international, and you stay tuned in and enjoy. I'm Samson Ladia Yanini. My outfit, as always, is by Latida. Next week, I'll call on you to support by funding a project that is going on to provide for isolation and treatment center, as is being done by fundraisers and Senyor Hosi leading. I have been chosen or challenged by Mama Vioso Abuaje to also contribute. So I will also be challenging some people, including all my guests here, to contribute to that fund. Thank you. Have a good afternoon.